May it please your lordship. In item number 6, 7, and 8, my lord. Yesterday we have filed our affidavit in reply. I may be allowed to bring the same on record, my lord. Lordship permits. Much obliged.
May it please your lordship. In item number 1 also, we have filed our affidavit in opposition in yesterday, madam. That may be last after.
Right, please, Lordship. No, I beg to mention item number 2, my lord. This item may kindly be taken at 2.
Number 2 will be taken up after item number 1. Item number 1 is at 2 o'clock. I'll take it after that.
All right.
May I please your lordship, with the consent of the other side, I beg to mention item number 4. Item number 4. The conducting counsel, Mr. KP Pathak, has some medical emergency. It may be adjourned for the.
Lord, I appear for the petition.
Yes, you do it.
Lordship,
You do it.
I'm ready.
2017 matter, Mr.
Yeah,
Bhumidi
I'm
doesn't.
told that the conducting counsel's father is indisposed.
But he's a senior counsel.
No, the senior one, KP Pathak senior.
Oh,
Otherwise, I'm ready, Lordship.
for APDCL, there is no counsel.
Yes, sir, there is counsel, but the Mr. Pathak was looking after this matter.
KP Pathak Junior was the conducting counsel here. His father
But
is
it doesn't
indisposed.
look nice. 2017 APDCL matter pending out here. Anyway, let's see. I'll accommodate. Let's see. I've got lots of other matters. We'll take it as a last item and I hope it doesn't reach us. But I'm not going to adjourn it.
May it please your lordship. Item number 14. It's a labor court matter which had come and the mediation had failed. So we sought the consent of the other side. We would like to, if lordship permits me, no, we'd like to file a small affidavit, short affidavit on the financial status of the petitioner. And where we stand before any order comes in. It's only whether retrenchment or resignation on that part only, because payments have to be made. So what is asked, and we would like to put it on record, if lordship permits me, not very shortly. We have the consent, of course.
You will time granted to the petitioner to file an additional affidavit in the matter. This matter on 2nd of December 2025.
Grateful, lordship. Obliged.
May please your lordship. My lord, I'm seeking lordship indulgence to allow me to move an unlisted, my lord, a motion matter tomorrow, my lord. Eviction matter, my lord, there on Patta land, my lord.
I'm bench 4, that's in bench 5. It's a bench 5 matter.
Number 6.
Lordship, I am seeking listing two matters, your lordship, regarding settlement of market, your lordship. And last it was listed on 25/9/2025. As
Okay. 12th of November?
if it is possible before 10, your lordship.
7th?
And I am praying for listing of a writ petition for admission column, my lord. My lord, matter is relating non-payment of allotted fund to the petitioner's vocational training institution by the skill development.
12?
My lord.
For admission, item 10 to 12, fixed at 10:30 AM.
We'll take your matter for later on. First, let me take there's another parted matter, na? His matter is also at 10:30. Yes, we should. You are saying first time.
So it's a keep it a bit.
Yes, what has happened, madam? Have you filed the additional affidavit?
It is.
This is a copy.
Take on it.
Yesterday we filed, my lord. Case number 113 is our letter to circle officer, my lord. Okay, may I come back for a- এইখন লগাইছে কেনেকে এইখন এইখন আৰু আপোনালোকে চাৰ্কেল অফিচাৰ যি আপোনালোকে
I don't understand paragraph number 4, the last line.
My lord, the whole portion of tag number 5 stored in the map within the blue line. My lord, in the map, the blue line is there, my lord. That is tag number 5, my lord.
This is tag number 5.
Yes, my lord.
Which is the whole, is the blue
Yeah,
line.
whole piece of land, and we are in possession of yellow part, my lord.
So isn't it within is the yellow part not a part within the tag number
Yeah,
5?
that is part of the tag number.
So
That's
then why it is outside the CRPF possession means? How is
No, my
it
lord.
mentioned? I don't understand this.
outside, my lord. My whole DAG number 5, one portion is inside the CRPF possession.
This
and-
is,
Yes,
this is
madam.
not what you are saying.
No, I'm saying that, well, that is,
The whole portion of dark number is shown here is
No,
within the
madam.
blue line, which is also outside the CRP.
some part
A
portion.
part
my
of it is
lord.
outside.
That should be, my lord,
But
my
isn't
lord,
it
that is
what
mistake.
should have been mentioned?
Yes, my lord.
This is not clear.
Yes, my lord. That is my submission also, my lord, before that, court, that the only part is in outside.
There's no quarrel that a
Yes,
part of
but-
it is
Yes, but
with
that is,
you.
that is. my-
But this is not what it has been mentioned.
The whole person is shown in the map within the blue line, which is also, matlab, one part is outside the, matlab,
But
that
why it
part-
is not made, this is a
that
very
is-
clever drafting.
This man, that is
This
my.
is not what affidavit is this. File a proper affidavit.
Yes,
Yeah. This is, you have to file an additional affidavit.
yes,
Because
sir.
this
down-
makes it very clear.
And down below, my lord, para 5, it says that sixth line from bottom, my lord, in order to address. Lordship got it, my lord?
It imperative first to demarcate and verify the
Very-
precise
Now-
extent of the land belonging to the petitioner.
I am
Such
told that.
exercise alone will lead to a conclusion. No, this is not done.
The-
This has already been done.
that-
My lord,
And
because
they know, my lord.
This
I
is
am told
already
that
done.
the
This, you
entire
have
meeting-
on your paragraph number 2 has said, madam, this is not fair on the part of your officials. I think we should call these officials.
No, my lord.
They are trying to,
One place affidavit, my lord, that
this is
my
not what
mistake.
you should have done.
And I'm
That
told the
This is
area
a very case of a very clever drafting. That is why I was reading.
No,
I was trying to read this paragraph number 4 twice or thrice to understand how is it. You have made it, why have you made it in this manner? The whole portion of dark number 5 is outside. Yes, there's no quarrel. You should have said that some
Part-
portion is outside and some is within.
that is missing, my lord. In
No,
the
that is not missing. This is a very clever drafting.
That is missing, sir. That is my mistake, my. That's why I'll.
So he has therefore made a false statement. I think we should draw contempt against this person who has filed this affidavit. What is his name?
Oh,
We
my-
initiate the contempt proceedings against.
my sir, kindly say my, I'll file.
And why should not we initiate these proceedings under 340 for filing a false affidavit?
That is not false, my lord. That is.
Absolutely, it is a false.
The whole.
An affidavit which has been filed in a manner by which it is trying to mislead this court amounts to a fraud.
That is my mistake. I have.
No, it
submitted
cannot be a mistake. He has signed it.
Yes.
We cannot understand this.
The whole portion of DAG is shown in the map within the blue line, which is also, my lord, one portion.
It is also outside the CRPF, meaning that is not there.
That is not there. That is
That
my.
means what?
Kindly-
This is not the affidavit which is. And why you are asking for demarcation once the demarcation has happened? Kindly see this.
Please see-
You have categorically said in paragraph number 2 that there has been a demarcation in presence of everybody.
My
Then
lord,
why are you asking at paragraph number 5?
my lord, because they have issued the notice, my lord, respondent number 4 also, my lord.
I'm not concerned. There has been a demarcation in presence of everybody.
My lord.
And paragraph number 5, you are asking again a demarcation. What is this?
Demarcation, not only me, my lord, kindly see, my lord.
We are not concerned. We are concerned that the petitioner's land is within your possession. That's what we are concerned. And that you have to mention out there. That is what you have made that statement on the last occasion, which I have duly recorded it.
Yes, my-
I wanted the same to be placed by way of an affidavit. This is not how you file an affidavit.
Mistake. That is my mistake.
We'll have it tomorrow. File an additional.
Today itself, my lord.
And regarding, my lord, this boundary, my lord, I am told that this, there,
You don't need to say anything.
Well, I'll pass today itself, and one more.
This court have duly perused the additional affidavit which have been filed by one Mr. Anil Kumar Dhyani, who is presently the DIG's GCCRPF. Full stop. The said affidavit, however, a perusal of the said affidavit, more particularly paragraph number 2, 3, and 4, however, is contrary to what was submitted before this court on 23/10/2025. Full stop. Ms. A. Gayan, the learned counsel who represents the respondents, further submitted that there appears to be some ambiguity in the language used in paragraph number 4, and therefore would like to file a fresh affidavit. Considering the above, list this matter again on 4th of November 2025 as 10:30 AM as the first item.
God bless.
You know how you
Malay.
file it. Madam, you have to be careful.
Yes, my lord.
Don't try to play with
Yes,
this
sir.
court.
Yes.
Item 10 to 12.
আৰু এটা মোচনো আছে নহয় মোচন এটা আছে এইটো দিব একেলগে মোচনটো ক'ত
May I please, your lordship?
Yes, item number 9 also, I am taking it together.
Only thing I would have done, I want to request my lord, lordship will kindly have considered a paragraph, my lord, where we have mentioned about our stand, why we have considered it. Even after submitting the same after the opening of the financial bid, it will be para 4. Para 4
On page,
of page 67 of the affidavit, running page 67, para 4. Para 4, para 5, my lord. And my lord, vital will be my lord, para 8 and 14 also. 14 we have placed the public importance, my lord, why it is required, my lord. It is more of, my lord, repairing work, my lord, urgently required. Now, my lord,
who has asked you not to take it?
No, the
This,
same-
this court is not
the-
asking you.
Yes.
But are you therefore saying that you are going to go by everything? Don't worry. If I have to dismiss his petition, I'll allow the other one. Therefore, I fix the 9 item.
My lord.
You cannot have a pick and choose. Item number 9 is the other way around.
Here, my lord, our stand is the same placing.
No, no, item number 9 is the other way.
Other way, it has been rejected on the ground that yes. on
Yes,
this
no, it
particular
is
ground,
exactly on the same ground
my lord,
that you have not submitted, you have suppressed that fact.
Yes.
So if you have did it for the one case and for the other you are taking a different thing, very well, no problem with that. That means you therefore submit that clause 4.3 you can give a go by in respect to calculating the available bid. And therefore I set aside on the ground that you have taken a differential statement in respect to the Pawan that one.
No, that's a different issue, but that's
No.
regarding experience, man.
Same thing. Yeah, no. You have, no, you see, on one hand, a person concerned, having not submitted his documents, you have rejected him.
No, because
No,
he
no,
has
no.
experience. He has no experience of the similar nature of job.
No, no, no. He who have rejected not for submitting the document.
That's
See,
right.
see.
No, that's
No,
right.
here also he is not submitting the document.
No, here, my lord, the format was uploaded. That's I'm saying, my lord, for the whatever is there in the affidavit.
Okay. We will pass an order and make it very clear. Go to the division bench. Division bench may help you, but I am going to set aside this. And that is why I brought in number 9. Where is Mr. Number 9?
One aspect.
No aspects. No aspects. Respects, all these aspects I've heard. I was about to dictate on that date.
One aspect of the
Yes, what is that?
the affidavit what they have stated is, first, the complaint was given, they have assessed the bid capacity. Now, basing upon an earlier work of a mega project of an highway, wherein 359 crores were not declared, ongoing work. The government of India has taken a stand that even if that is taken into account, the bid capacity is not affected. Therefore, it may be an omission, but that is not a material representation. That is there in their minute, which they have attached with their affidavit. Basing upon that, lordship, since what is
No,
reflected.
therefore, I am taking it. Along with that, for another matter, they have done another thing.
There.
No, therefore, I am saying, you see, the PWD has to work as one. For you, there is a pick and choose and say that you are being allowed, whereas they have rejected him. We do one thing. If I am going to dismiss his petition, I am going to allow his petition. Which one?
And I leave it to your lordship.
Yeah. No, no, you tell me either of it, because these are both cross claims.
My lord, they are relying upon my lord clause 23.5. My lord, they have been categorically laid down that after opening of the technical bid, a 7 days period window.
Understood. The 23.5 says that 7 days time. But the fact that you have been taken for a ride is not, doesn't mean, the PWD department doesn't mind taking into account that he has quoted 42% less. Whereas the petitioner herein has quoted 41.7% less. They're more concerned with that. This is not arbitrary, then what else can be said to be more arbitrary?
I mean, the sanction of the central government, we have to complete the entire work within 6 months. So we are in a hurry. That's the public. That letter dated 23 February 2018. So the time period is mentioned as clause 10.6.
I can do one thing. I can make it parted and keep it pending for another 6 months. I think that would be enough for take care of what the central government says.
If I'm relying upon a judgment for a limited purpose. Lord.
No,
Only for a
there's
limited.
a stay, na?
Lordship.
There is a-
Huh? Fantastic. Let it operate. We pass a stay there also.
My case, my lord.
In his case also, I grant a stay and let this matter go on for another. Absolutely no. Means if PWD is going to take up the treatment in respect to this petitioner in this manner and for him in a different manner, either you accept his, you accept his, you have cancelled, you say that okay. Do one thing, the PWD must be very fond of him. So therefore, give him the contract and also give him the contract.
The authorities are different.
No, authorities not. We are concerned with the PWD secretary.
So that-
No, you don't leave it to me. I will therefore say, okay, if PWD wants him, very well, have him. Then have him also. Same.
In that case, my lord, what is the facts when it was informed better than?
Then also his bid capacity doesn't change. We stay there, we do one thing. You are enjoying a stay, na? You enjoy your stay. We grant a stay in his case and grant a stay and ask you as to whether the bid capacity, does he lose the annual bid capacity taking into account? And then we see. Better. Chalo.
No, lordship passed out.
No. Here I'm saying it in his matter and asking you the same thing. Same question. Where you have done the same thing for him. He has not also taken any steps. The other side has also not taken a steps within 7 days. 23.5. It is there here also.
I checked the morning. That's my confirmed.
No, we grant a stay to him and we'll see when the matter takes up.
Now, I being the L1 bidder, I am.
You won't get it. Till I am here sitting taking up this matter, you won't get it. That is for sure. You won't get it. But the fact remains that let us also take up how the PWD functions. Issue notice. You have to be more careful. You can't have, okay, I don't like his face. It's a case of face choosing by the PWD. I'm telling you, this is a case of face choosing. You don't like him, so you adopt this particular criteria that he did not mention about one work, although he had mentioned about one work. But in respect to him, you say, he must have forgotten. And when you are the person who have granted him, I would have understood that he had not disclosed about that particular thing as regards it's a central government project. He didn't know. You didn't have any notice. You are the person who have issued him the contract. Is it not all electronically done? Is it not available in the computers that his work is there? And now you take up a point that he did not raise within 7 days. And in his case, there is no raising of such issues within 7 days. So we issue and stay, then we'll see. Then both of them is gone for another 6 months. Let's see how you work.
No,
The
that
PWD.
will be the entire. So the funds will go. Then the roads are in a very bad condition.
My case is a building.
If the roads are in a bad condition, you can't help it when the PWD has a pick and choose policy. Mr. Gokoi, this is not fair on the part of the PWD.
In that case, let me have the my clarification in the other case, Lordship will take up then, my lord, on the, 4 hours on 5.
2 o'clock.
Yes, let me have the instruction.
With his annual bid capacity, if you take him, would he then meet? Because all the records which you have taken, no, if that be so, then he should also get the benefit.
What is the difference?
No, it is the PWD.
The
What is the
commission-
difference? Show me what is the
Yeah,
difference
pending
between the two? What is the difference of
in
this
the
contract and
other
that contract?
The other case is the PWD,
Health and education, my lord.
health and education.
Chief engineer, health and education.
This is a short-term maintenance work, NH division in the state of Assam, Ministry of Road Transport through PWD. This is his work
Yes, other 3 cases. my lord.
for maintenance.
Yes.
Okay. And for the purpose of
That
him,
motion matter, my lord.
Motion matter, my lord.
It is the chief engineer, health and education.
so what? CW, Chief Engineer, PWD building, and that is NHY. But it doesn't falls under the ambit of the Commissioner and Secretary PWD.
Well, otherwise, my lord, the health department is same.
Then-
Commissioners, no, commissioner and secretary building is different. Otherwise, my lord, NS is different, my lord, roads is different. There are some.
But I think this is,
But whatever is there, my lord, I am just placing the, my lord, facts in the affidavit.
no, there is no point. I can very well cancel him. I can very well pass an order against him. And against you, you can give it to him, the petition. Because he is the second highest. You are anyways getting at 41.7% below. Or give it to the third, who is even quoting 11% below. That's your lookout. If you want to save 3 lakhs, that's the difference between both of them. And give disregard to the law, you can do it.
My lord, both cases are there, that's the, my lord. Yeah. Coincidentally, my lord, the other case also came.
That is why the moment I got this case, I therefore picked it up today. And I wanted to dispose it by one common judgment, thereby allowing history and dismissing him. But now if you want, no problem, let it go on for another 6 months. Then the money will also go away. Fantastic.
But sometime, my lord, let it be after half an hour, or after the next item. my lord. Just because in other case, my lord, at least, my lord, let me have the instruction from the health and education department. It will be just.
You want to withdraw his rejection and give it to him, give it to him. He's the lowest bidder, 2 crores 51.
My lord.
And the other is 2 crores 63. He's the
But
lowest
I have the
bidder.
financial capacity, my lord.
Huh?
I have the, but tomorrow, yesterday,
No, he also has the, after that minus plus, he also has.
my lord.
Give it
No,
to him.
with both the authorities, my lord, as well as my lord, NH, as well as my lord, let me after now.
Get it,
Ultimately,
because you cannot have this to pick and choose.
whatever order is.
Because
passed, it will be-
that is why I am concerned. Once I pass an order of dismissing his requisition in days, this would become a precedent for you in all cases. And in every case, they will take it up. And then you are in more trouble. And for, I don't know, your person is interested in giving it to him, the PWD in a longer run would suffer. And if you don't want, it's okay. For him, you like this respondent, private respondent so much that the PWD wants to suffer. Fantastic.
So after some time, my lord, I can make them explain, my lord.
Explain it. But otherwise, tell him.
That too, my lord.
No, let it be after.
At 2, I got many more methods.
For hearing item 3.
Right, please, your lordship.
Yes.
My lord, the petitioner is running a wine shop.
What is the matter about?
My lord, a cancellation notice was issued, a notice was issued for shifting on a complaint by the respondent number 6, who claims to be an educational institution, my lord.
IMFL,
I am,
and it's going on for last 2015, 10 years.
yes.
What is this? Where is the other side?
Don't know.
So you have been asked to shift
Yes,
and you got to stay.
we got a stay and we have been asked to shift on a complaint by respondent number 6, who claims to be an educational institution under the relevant provision of law. But my lord, they are not recognized. Their the main premises to which run is at Ahumgaon, not at RG Borwa Road, my lord.
Huh?
My lord, for a educational institution to raise a complaint for shifting of a IMFL wine shop, they have to be recognized under the law. A recognized educational institution can only raise a complaint. And however, they are running these tenanted premises in a commercial complex, and actual their permission by the education department is at Ahumgaon, my lord. That is the whole crux of the matter, man. And anyway, my lord, there by February last time when this matter came up before this honorable court, the council for respondent number 6 submitted by January end or February, they are shifting it to Ahumgaon permanently, the educational institution.
Who?
The respondent number 6, SK Hazarika.
Who is appearing for them? Who is appearing? No excise department. Where is your located?
My lord, at RG Borwa Road, that petrol pump, there is a complex, my lord, SK Hazarika.
Haji Barwa Road, which petrol pump? There are many petrol pumps there.
Nova Service, my lord. Nova Service station, just opposite to Jew, my lord.
Ah.
Then there is a road towards Srinagar. Yeah, it is called Srinagar by lane. And just adjacent to that petrol pump, there is a complex, commercial complex, lots of shops in there. The wine shop is located there. And this SK Hazarika College is also located there.
But what happened to those matters? That was there was a big issue once.
Arun Pathak, my lord.
What happened to that?
My lord, the high powered committee was constituted and they gave some guidelines. And my lord, as per their guidelines and as the rules were amended, and now 2016, from 2014 onwards, even if a wine shop is there prior to establishment of an educational institution or a religious institution, then also they have to shift, provided a sufficient period of notice is given. In the instant case, this SK Hazarika College at there where the wine shop is located, the recognition was not given for that matter. They have to have their own land, they have to have their own infrastructure, which is located at.
But that's 183, 183,
Yes,
189 or what?
183. Yes,
183 of the excise rules say to be
Yes.
a recognized
Yes.
institution or an institution.
Recognizing.
Let's see, 183.
My lord, the respondent number 6 have filed an affidavit, they have annexed the 183 and excise manual also. Now it is 389 perimeter area.
We have to go by that law at that point of
Yes.
time. Oh, but by the way, how is the 2016 rules treating the earlier rules?
My lord, it has repeal and saving said that it has completely replaced the 2000 earlier.
Huh?
It has completely replaced the earlier rules, my lord.
Completely replaced, but what rights, if a person is holding a license or a shop
My
in terms with the earlier rules,
My lord.
and now in view of the new rules, they are being affected,
My lord,
then what happens?
My lord, because of the proviso contained in the amendment, the new rule will apply because the proviso says even the wine shop is prior to establishment of the.
2016 act rules conduct.
And the 83 rules are also annexed, my lord.
Oh, huh?
The 183, the prior unamended portion of the rule is also there, exactly perimeter area, my lord.
200 and
Lordship will kindly come to section 289 of Assam Excise Rules 2016. 289.
yes.
289-2. Then explanation, the second explanation, my lord, educational institutions, may I read it? Educational institutions for the purpose of this rule means any primary school, middle school, and high school recognized by the state government. So recognized word is there. And the last proviso, provided that even when any.
But you see, educational institution is a wide term. It is not only the recognized by the state government or the central government
Yes,
or any college affiliated to any university established by law,
yes,
but
my lord.
does not include any private coaching or tutorial institution.
Yes,
But isn't it up, the recognition may be there, but it may be a branch of it. A branch also is recognized. Do you need to recognize each and every branch of an educational institution?
No, my lord, if you, lordship will kindly peruse the permission granted to this college, they were granted temporary permission and with a rider that you have to shift it from to the permanent within 3 years. This is on record, my lord.
You are appealing for response number 6.
No,
Are you shifting?
my lord, I have done an instruction, my lord. Because there are two places of institution. One is in Boda Market Complex, my lord. This honorable directed to cause an inquiry into the matter. We were functioning from there. The report is there, my lord, in the record of this court, my lord. It is submitted on 12/8/2025.
Lordship,
In
before
terms
the order is
Yes, sir, in terms of the order.
order dated 5/8/2025.
the report has been submitted. 8,000.
5/8/2025, an inspection was directed to be carried out. Para 3 and
A inspection report.
Yeah.
inspection report.
This report disclosed.
In pursuance to the directions passed by the students, the procedural inspection was carried out at the premises of R.T. Burwa on Niman and at the premises at Ahungaon on Niman. Upon examination of record, it was observed has obtained permission to commence academic classes in art science from students. It also observed from the document to the land documents of
Ahungaon. That is very important, my lord.
at the time of applying for academic appeal on vehicle of demand. Institution had submitted a across various streets about the date of the documentation. Look. Wait. You see, for the purpose of setting up a college or a branch of a college, you need to take a permission.
Yes,
You have taken a permission.
yes, yes.
So Enough.
Page 42.
Matter.
Permission was in respect of my lord that.
No, no, in that premises, there has to be a permission and there is a permission given.
42, my lord. That has been continuing since then, since inspection report.
So matter ends.
Letter
No,
complaint.
my lord,
Finished.
I will place the permission. The permission itself speaks that they have to shift it to the regular place within 3 years. ma'am.
But they have not shifted. That means they have been allowed.
Yes, yes, my lord.
And there is a
We
report,
conduct
let us see the
petition
report of the AC.
No, they have shifted. They are running their place in the Ahumgaon properly. Only,
No, 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 they are running in both places.
Yes,
Look, look.
so if your lordship goes to the act under which the permission is given, they don't fulfill any of the requirements.
This is the inspection. Permission given in 2002.
yes.
Wine shop since 98.
Junior college is to be shifted to its own building constructed in its own land within 3 years.
Yes.
Building which permission shall be withdrawn.
And they have done that, my lord.
Then 2002. Then these are photograph.
Yes, ma'am. This is-
Yeah, it is running.
Yeah.
But the only thing is, I'm not understanding whether there was this after 3 years, what did you do? How are you running it? Your permission was given in 2002 for a period of 3 years.
Yes.
But how are you running after that?
All of them, from time to time, my lord. There are a lot, our examination is being held there, my lord. They are being regular
Yeah.
inspection, my lord.
Have they extended? Where is your materials to the effect?
Lordship, meanwhile, Lordship will kindly peruse the regulation on recognition of higher secondary and junior colleges 1989. My lord, there are 2 appendixes which lays down the requisite criteria for giving a permission. It doesn't fulfill any of them. And,
You are not challenging his permission.
no,
Are you challenging his running the institution? No. But the fact that you are trying to take a plea that it is not recognized
because,
from a recognized, yeah.
yes.
But whether it is recognized or not, that is the only issue. If it is recognized, you are not challenging it, so we are not going to go into those aspects. Yes.
Because
How are you running after 2005?
2005.
Sorry, state of affairs, Mr. Ghosh.
Obtain instruction, there is something, otherwise there can.
It's a matter of 2016 and you
It's a
don't
matter
know.
of decision.
Isn't that the institution? Isn't it their specific case which have been saying from all this while that they got the permission for 3 years?
My-
Then, yes. Respond number 6, council, of no use. Mr. Gogoi, what do you say? The fact that there is a college or whatever may be, isn't it an infraction to 289?
Yes, Lordship. Our stand is that if a wine, if a shop comes before, after the establishment of an institution recognized as defined by this rule, your lordship, that shop has to go. But it has to be as per rule 289, it has to come under that clause, your lordship. That's the our stand.
So when did they get the license?
We
98, my lord.
98.
98. Annexa 1 to the writ petition.
98.
So then what is the problem?
Thereafter, the institution came, the
Ah.
institution saying that they are affiliated.
Whatever may be, but 98 he was license was
His
there.
license was there. 289, finally take your lordship.
289 to last proviso, my lord.
Last proviso, your lordship.
Where?
Provided that the last, even when any place of public worship or education institution or hospital comes into existence subsequent to the establishment of licensed premises, therefore a distinct provision shall apply subject.
Only are given a reasonable opportunity to seek
Yes.
or to leave. So you have got 10 years.
No, my lord. Yes, Lordship is very true, but Lordship will kindly see that is a commercial complex as reflected in the inspection report. And not only the liquor shop, my lord, there are other shops also, my lord. They are otherwise also shifting by January.
Mr. Patwari, I fail to understand. I hope you understand. Right to carry on business
My lord.
of liquor, not a fund, it's not a right.
Understood.
It's a privilege.
Understood.
So you have been given a privilege. So if you are given a privilege, then after, when the law does not permit you, you cannot. When are you vacating?
No, my lord, Lordship will kindly see the other aspects.
No, others I'm not looking at. It is a privilege. You have to forgetting. It is not a right.
My lord.
Not right.
This is the most essential aspect of our right. Even in, I remember while reading a matter pertaining to, as a lawyer, there were a lot of matters done for entry tax, challenge to the entry tax and all. Then some of my colleagues challenged on the question of entry tax on liquor. Initially, the matter came before me, but I said that no, you cannot. There is a judgment of the Supreme Court on that because they don't have a right under Article 304, under Article 301. They don't have that right. It is because it's a privilege. One has to understand that. And if you don't fall within the ambit of the act, you're gone. In fact, the matter should have been finished in 2016 itself. And the court passed that order of stay, only giving you a because at that point of time, the counsel who was representing say that he has a right of a reasonable opportunity. And then the court stayed it till the returnable date. Now you had 16, today is
9 years.
9 years.
Well, that-
When are you shifting? Answer is, when are you shifting? You
Lord-
think about it till I finish up the other matter with Mr. B. Gogoi. Then I pass that order.
Lordship will then kindly take up tomorrow. my
No,
lord.
no.
I'll obtain the
Okay,
instruction.
tomorrow with a cost of 1 lakh. No,
Let
no,
me-
because you see,
Lordship will-
I will take up this matter tomorrow on a motion day. On a motion day, taking away the rights of many of the litigants who have otherwise other matters and because of the convenience of yours.
No.
So don't worry. This 1 lakh, I'll put it to the Bar Council, Bar Association, and it will be paid to equally to all the councils who appear tomorrow.
then
1
day-
lakh?
Day after tomorrow, my lord.
1 lakh.
No, my lord,
Thereafter also the same thing appears, then it will be given, I'll make it 50,000 because it's not a motion day. Then you have this divided amongst all the councils. Okay, 50,000.
Lordship will kindly bear with
On
me.
the matter, will
Kindly bear with me, my lord. Let me have the instruction and Lordship.
that is why I'm allowing you to have the instruction till I finish up Mr. B. Gogoi's order.
Lordship will kindly.
50,000 or 1 lakh, whichever you feel like.
Lordship will kindly bear with me. Lordship will kindly see. Lordship, they are otherwise shifting. They don't fulfill the requisite criteria under the law. and
There
for the-
is a college. It is not a private institution.
No, that
It is not a private, you see,
no, that
which
is
shall
our
not
dis-
apply is a tuition class.
We are not disputing that. We are not. That
No,
is
no,
not
no, no.
true.
You have run for long. Okay, I will give you a date on 1/11 as the first date. 1/11, subject to a cost of 50,000,
No, that possible.
which will be reimbursed if there is less matters.
No, my lord, that
No.
will be.
You cannot take this advantage. It's on a matter or not. It has come up for hearing. I have heard Mr. J. Patwai, the learned
Respondent
counsel.
says council is.
Not necessary. I am not concerned with him. I am concerned with Mr. R. Gokul. Huh? Right. So this will be second item. So there is already one other first item. This is being, the second item.
But no
Mr.
pos-
Heard
possibility.
Mr. J. Patwai, the learned counsel appearing on behalf of the petitioner. Mr. R. Gokul, the learned counsel appearing on behalf of the excise department. And Mr. B. J. Ghosh, the learned counsel who appears for the respondent number 6. The issue which is involved in the instant case is as to whether the petitioner's license, the continuation of the petitioner's license, petitioner's IMFL off license, SHOF, is permissible in terms with Rule 289
Two.
of the Assam Excise Rules 2016. Inasmuch as, admittedly, there is admittedly, a college, admittedly, the respondent number 6, which is a junior college, has a branch, has a branch which is running within the same campus, within the same building. This court, though Mr. J. Patwai, the learned counsel appearing on behalf of the petitioner, has submitted that the respondent number 6 is not a recognized college. And as such, it would not come within the meanchief of Rule 289 of the Rules of 2016. But from the materials on record, it appears that the respondent number 6 is running its HS classes, as could be further seen from the report which have been submitted by the Deputy Secretary, RPR, Assam State School Education Board on 12/8/2025. It further appears that under no circumstances the respondent number 6 can be termed to be a private coaching or a tutorial institution. This court further is aware of the fact that the right to deal with liquor is not a right conferred by the Constitution. It is merely a privilege, and as such, the said privilege has to be exercised within the confines of the law, extant law. As the matter was heard at length, Mr. J. Patwai, the learned counsel appearing on behalf of the petitioner, sought for some accommodation. Considering the above, list this matter again on 1/11/2025 for further hearing as item number 2 in the list.
Deep stabilization.
It will record to file. Yes.
They have understood. They have understood. My lord. So if you give a precedent, my lord, it will be there, my lord, this office.
It will have far-reaching consequences tomorrow. Because if I give here, na, he will every time everybody will come. And it will be a floodgates.
Okay.
I'll dismiss your case. Let me come back in 5 minutes. We come back and then dictate.
Only that, my lord, retender will, within the time limit, will do the retender.
No, I will only set aside his selection.
Technically.
Thereupon, you want to cancel the tender or retender. You want to cancel or retender, then you can go ahead. That is your lookout. Or should I mention it? It is absolutely within your purview because he's only challenging his qualification. Yes, your name?
Lordship T. Kashyap, your lordship.
E.
T. Kashyap, your lordship.
T. Kashyap. Heard Mr. T. Kashyap, the learned counsel appearing on behalf of the petitioner in WPC number 5163 of 2025, WPC number 5164 of 2025, and WPC number 5165 of 2025. Mr.
I alum.
I am the learned counsel.
Item number 9,
So and so.
5969.
No, that I know. So and so who appears on behalf of the writ petitioner in WPC number 5969 of 2025. Mr. B. Gogoi, the learned additional advocate general, as well as the standing counsel of the PWD, appearing on behalf of the respondent authority in the 4 writ petitions, and Mr. So-and-so, who appears on behalf of the private respondent in WPC number 5163 of 2025, WPC number 5164 of 2025, and WPC number 5165 of 2025. All the 4 writ petitions are taken up together, taking into account together for disposal by this common judgment and order, taking into account that the issue involved in all these 4 writ petitions are one and the same. It is but pertinent, however, to observe that the writ petitioner that the writ petition being WPC number 5969 of 2025 is also taken up, is also being decided along by this common judgment and order on the ground that a totally contrary stand has been taken by the PWD authority insofar as the petitioner is concerned to that of the stand taken by the PWD in the other 3 writ petitions. At the outset, this court would first like to deal with the facts in respect to the 3 writ petitions being WPC number 5163 of 2025, 5164 of 2025, and 5165 of 2025. The chief engineer PWD NH Works, Assam, had issued a notice inviting tender dated, what is the date?
21/6/2025.
21/6/2025, calling for tender, calling upon bidders for maintenance works and activities for various sections of the national highway. In WPC number 5163/2025, the package in question is at serial number.
9.
Where?
Lordship,
Serial number 9.
Number
Serial
108.
number 9 of the notice inviting tender,
additional.
which reads as under. It took page 108. Huh? 9. In WPC number 5164/2025, the package is at serial number 8 of the notice inviting tender, which reads as under. In WPC number, next. 108. In WPC number 5165/2025, the package in question is at serial number 12 of the notice inviting tender, which reads as under. Get me the records of those. Five one six three is which item?
The other
One?
item 10. The other record, the minus one all are there in the other.
You have given me two files.
One is common where that shows reply of the respondent vote that is there. Otherwise, this one there are 3 records of 3 separate tenders. Or items.
NHR 22/2025 has 3 records.
No. 3 records are pertaining to the various this project. Of the item. That I am presenting.
NHR 20,
NHR 22 is item number 10. NHR 22 that record of item number 10 minutes and all are there.
the item number, tell me which read petition.
Item number 10.
Yes, it is
5163.
63 is what?
516.
5163 is which is the record? NHR
NHR it is 23. NHR 23.
23 is not before me.
This one.
This court have duly perused the records which have been produced by Mr. B. Gogoi, the learned additional advocate general. In respect to the contract, in respect to the package at serial number 9 of the notice inviting tender, which relates to WPC number 5163 of 2025. As many as 4 bidders submitted the bids, which includes the petitioner as well as the respondent number 6. 6, na?
6.
Respondent number 6.
Lordship, respondent number 4, your lordship.
4. Respondent number 4. In respect to the package is serial number 8, which is in relation to WPC number 5164 of 2025. There were as many as how many bidders?
Well, the report of NHR 22.
How many bidders were there? Which is the file?
NHR 22.
As many as
7 bidders, your lordship.
7 bidders. In respect to the package is serial number 12, which is in relation to WPC number 5165 of 2025. There were as many as how many?
7.
7 bidders. The issue which have arisen in all the 3 writ petition is that the petitioner herein, who is common, petitioner herein, who is the common petitioner in the 3 writ petition herein, who is the common writ petition, have alleged that the respondent number 4 in all the cases,
In all the cases.
4, have alleged that the private respondent technical bid ought to have been rejected
Bill. Financial side.
on the ground of failure to submit certificates of the documents as specified in clause 4.3 capital B of the instruction to the bidders. In view to further elaborate the case of the writ petitioner in all the 3 writ petitions, it is pertinent to take note of that clause 4 of the instruction to the bidder stipulates about the qualification of the bidder. In terms with clause 4.1, it was mandated of the ITB. It was mandated that all bidders shall furnish the information and documents with their bids in section 3, qualification information unless otherwise stated in the appendix to the ITB. Clause 4.3.a, capital A. Of the ITB stipulates that to qualify for award of the contract, each bidder in its name should have the following. Now, should have A, achieve the minimum average annual financial turnover bracket in all classes of civil engineering, construction and maintenance works only bracket close, equal to the amount indicated in the NIT during the last 3 years ending 31st of March of the previous financial year, duly certified by the chartered accountant, and have satisfactorily completed at least one contract of highway, that is NH/SH work bracket not less than 90% of the contract value as a prime contractor or as a partner of the JV for similar works during the last 5 years ending last day of the month previous to the one to which the bids are invited. In the manner stipulated in subclauses Roman 1 to Roman 4. Clause 4.3 capital A small b further stipulate as to how the escalation factors would be used to bring the value of completed work to the level of the current financial year. And in order to do so, a multiplication factor has been added, have been mentioned. Whereby with each year the multiplication factor increases with each passing year, which for 2024-25, the multiplication factor is 1.1. And in respect to year 2023-24, the multiplication factor is 1.21, etc. Clause 4.3, capital B, is of relevance And the same is reproduced here in under page 116. In terms with the said clause, above quoted clause, it would be seen that each bidder must upload the scanned copies of the following documents along with the submission of the online bid. The documents are an affidavit on a stamp paper duly attested from the notary public that the information furnished with the bid document is correct in all respects, and such other certificates as defined in section 3. It is further mandated in the said clause itself that failure to submit the certificates of the documents as specified in subclauses 1, Roman 1 and Roman 2 of clause 4.3 capital B shall make the bid non-responsive. Clause 4.4 of the ITB is of great relevance. And as such, the same is reproduced here in under 116. From a perusal of the say above quoted clause, it would be seen as to how the available bid capacity would be arrived at. It is very pertinent to take note of that while calculating the available bid capacity, one factor has to be also taken note of. That is the value bracket escalation factor as specified in clause 4.3 capital A, B. To bring the value of the level of the current financial year, that is 2025-26, bracket close, of the existing commitments and ongoing works to be completed during the next 1 year, bracket, period of completion of work for which the bid is invited. It is therefore seen from a conjoint reading of the above mentioned clauses that in order to grant a contract to a particular bidder, there is a requirement to arrive at the available bid capacity. And in order to arrive at the available bid capacity in the manner stipulated in clause 4.4 of the ITB, the fact that there is an existing commitment and ongoing works are therefore required to be mentioned. In other words, without the disclosure of the existing commitments and ongoing works, the available bid capacity cannot be correctly arrived at. Next. This court further finds it pertinent to take note of clause 4.5 of the ITB. Wherein it is mentioned that even if the bidders meet the qualifying criteria, the bidders are subject to be disqualified under certain conditions. The conditions are enumerated in subclauses Roman 1 and Roman 2 of clause 4.5. In terms of subclause Roman 1, if a bidder had made misleading or false representation in the forms, statements, affidavits, and attachments submitted in proof, and in subclauses, subclause Roman 2, the record of poor performance such as abandoning the works, not properly completing the contract, inordinate delay in completion, litigation history, or financial failures, etc., or debarring from work, etc. This court further finds it pertinent to take note of, taking into account that subclause Roman 1 of clause 4.5 deals with misleading or false representation. Clause 34 of the instruction to the bidders appears to be relevant, in as much as in terms with clause 30.4.3 subclause B, 34.3B. Fraudulent practice have been defined to mean a misrepresentation or omission of acts or suppression of acts or disclosure of incomplete facts in order to influence the bidding process. In the backdrop of the above, in the backdrop of the provisions as mentioned here in the above, it is pertinent to take note of Section 3 of the bid document, which relates to qualification information. Sections 3
Page number 135, Your Lordship. 1.4B.
of the bid document stipulates that the information to be fed in by the bidder in terms with Section 3 and documents submitted in physical form will be used for the purpose of post-qualification as provided for in clause 4 of the instruction to the bidders. taking into account the issue involved, this court finds it pertinent to take note of clause 1.4b of section 3 of the bid document. This clause having relevance, the entire clause having relevance is reproduced here in under with it by 135 whole bit. From the above quoted clause, it would be seen that in terms with subclause 1, there's a requirement of furnishing the existing commitments and ongoing works in the manner stipulated therein. It further mentions that there is a further requirement of uploading certificates from the engineer in charge of the rank of executive engineer or equivalent, and also supply original or certified copy of certificates in the physical form envelope. Subclause Roman 2 refers to the details of work where bids have been submitted and accepted. That is where contract signing is pending. Mr. Gogoi, this similar provision will be there in the other contract, na?
This particular one is 4.1. The chart one.
No, in his case.
Yes, yes, it is there.
So have a look at it so that I can then just make a reference to that passing reference. He have mentioned he's filed his affidavit, huh?
Yes, in the initial affidavit, it is
Uh,
4.7, page 74.
No, 4.7,
Seven.
page 74, na?
This 4, not 4.4.
No, this is okay. But where's the chart?
Yes, chart is at page.
That is page, my lord.
Page 96.
Page 96. Huh?
Bottom, my lord, 1.4, then 97 is the chart.
Ah.
But that 7 years, my lord, that is not.
Huh?
That 7 years, my lord.
Page 95 onwards, my lord.
No, it is.
No,
1.4.
his case will come under this one, na?
96 page, my lord.
Page 97.
97 is the chart. Starts at page 96.
No, you see existing commitments and ongoing work. Information works for which bids have been submitted and works which are yet to be completed as on that date of this bid. So this is it, 1.4a,
A, yes,
isn't it?
yes, 1.4.
ठीक है लो Roman 2 subclause Roman 2 of clause 1.4 small b is in respect to furnishing details of work for which bid has been submitted and accepted. That is where contract signing is pending. It further mentions that where LOA has been issued, such LOA has to be uploaded. Subclause Roman 3 of clause 1.4 bracket B mentioned the formula by which the bit capacity, annual bit, the available bit capacity is to be calculated. The pertinent aspect being that if there is an existing commitment and ongoing work, or when their bid has been submitted and accepted, the same has to be duly mentioned for the purpose of ascertaining B, which is required to be taken for the purpose of ascertaining the available bit capacity. The materials on record show, no, the admitted materials on record show that the private respondent in WPC number 5163 oblique 2025, 5164 oblique 2025, and 5165 oblique 2025, while submitting the bid, did not mention the requirement of the mention about any existing commitment. Though, admittedly, on 30th of April 2025, the Chief Engineer PWD NH Works Assam had issued a notice to proceed with the work to the private respondent. For construction of inspection bungalow cum conference hall bracket G+1 at Mongoldoy bypass under the contingency provision of job number 15 oblique AS oblique 2021-22 oblique 234 under PWD Rongia NH division, Rongia, in the state of Assam at a contract price of rupees 46,49,000. This board further duly takes note of that the petitioner in WPC number 5163 oblique 2025, 5164 oblique 2025, and 5165 oblique 2025, on coming to learn that the respondent number 5, private respondent, did not mention about this existing commitment, submitted an objection before the tender evaluating committee. The tender evaluating committee, the respondent's authorities, did not go into the said aspect which was objected, but rather rejected the petitioner's objection on the ground that the petitioner did not submit the objection within 7 days. And it is under such circumstances the 3 writ petitions were filed before this court. The materials on record show that this court, by the order dated 5/9/2025, while issuing notice directed that no letter of acceptance should be issued to the private respondent in all the 3 writ petitions. First. The record reveals that the respondents have filed their affidavit in opposition. Wherein the respondent authority justified such stand on the ground that though the respondent authorities were not aware of the existing commitments of the respondent number 4 of the private respondent, but on coming to learn from the objections filed by the petitioners, they made an assessment and found out that in spite of that, even if the private respondent have not disclosed the material information, it would not have materially affected the available bid capacity. Further to that, it was also mentioned that the private respondent had quoted a lesser price to that of the petitioner. And as such, it would be in the interest of justice that the respondent authorities be permitted to allocate the contracts in question in favor of the private respondents. The private respondent has also filed an affidavit in opposition. You have not filed. The private respondent, however, have not filed any affidavit in opposition in support of its case. At this juncture, this court now finds it relevant to take note of the facts in the case of the writ petitioner in WPC number 5969/2025.
The 7 days part, maybe 7 days time. The complaint was lodged after the expiry of 7 days in terms of clause 23.5. That was our ground of rejection of the representation of the petition. That it was.
Let me submit it at your submission. Na?
Yes, only my submission.
No, I'll make it. Let me now take the facts. These are
Yes,
pleadings. These are pleadings I'm taking in.
Okay.
Therefore, I didn't say anything. Because his submission will be we forgot.
Yes, we forgot.
There was a mistake, he forgot and he later on submitted. Because that is why I can't say that.
Yes.
No, now. This is a case where the respondent PWD have taken a completely had taken a 180-degree somersault to the stand taken by to the stand taken in WPC number 5163/2025 5164/2025 and 5165/2025. Mr. Counsel, you are lucky because he filed this case. In this instant case, the chief engineer, PWD building, bracket, health and education, had issued a notice, detailed notice inviting tender dated 4/7/2025 for the purpose of thereby calling bidders for the purpose of carrying out the balance work for construction of the model secondary school in tea garden areas of Assam under RIDF-28, Roman 28, at Arkatipur Tea State in the district of Kachar. The petitioner herein, along with 4 others, participated in the said bid process. It was found during the technical evaluation that out of the 5 bidders, 3 were technically non-responsive. And the petitioner, along with 1 MP enterprise, were held to be technically responsive. Thereupon, technically responsive in terms of the evaluation carried out on 21/8/2025. Pursuant thereto,
My lord, it's held on 16th of August, my lord. 16th of August, 16/8. That is a page 37.
pursuant to the technical evaluation carried out on 16/8/2025 and uploaded on 21/8/2025. Pursuant thereto, on 18th of August 2025, it was intimated to all concerned that the petitioner, along with 1 MP enterprise, were found technically responsive and their financial bids would be opened on 21/8/2025. Upon opening of the financial bid, it was found that the petitioner herein was the lowest bidder, having quoted 2,51,84,489.99, whereas the other bidder, namely MP Enterprise, quoted 260,56,100. After almost 1 month thereafter, the petitioner was issued a notice on 15/9/2025. This aspect is relevant, as will be seen in the later stages of the instant judgment, informing thereby informing that to submit a detailed justification regarding suppression of ongoing works submitted in the technical bid document for the work in question. And the petitioner was asked to submit the letter within 3 days of the issue of the, within 3 days. The petitioner thereupon on 16/9/2025 submitted a reply stating inter alia that the second work of the Janata College Kachar allotted to his firm on 16/6/2025 is yet to have any physical progress and running through various uncertainties. And it was further mentioned that hence, due to above uncertainties, the petitioner was not in a position to ascertain whether the work would be completed or cancelled, resulting in non-disclosure of the work in the existing commitment by the petitioner as per the aforementioned clause. Be that as it may, the respondent authorities finding the petitioner's explanation not to be satisfactory cancelled the entire tender process. Via the communication dated 6/10/2025, which is the subject matter of the present challenge. The petitioner further assails the retender notice dated 7/10/2025 issued in the Assam Tribune, in the daily English daily Assam Tribune dated 7/10/2025 in the present writ proceedings. Taking into account the above issue, the present in the backdrop of the above, let this court now deal with the respective submissions on behalf of the parties. Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, submitted that in terms with clause 4.3, capital B, read with section 3 of the bid document, 4.3 capital B of the instruction to the bidder of the ITB, read with section 3 of the bid document, the technical bid of the private respondent ought to have been rejected on the ground of non-disclosure of the materials or non-disclosure of the contract pertaining to construction of inspection bungalow cum conference hall G+1 at Mongoldoy bypass, issued by the same authority The learned counsel submitted that without the disclosure of the existing contract, the available bid capacity cannot be ascertained. And in the instant case, had the petitioner not intimated by the communication or by raising objection, the respondent authorities would have given a clear go-by to the provisions of the tender documents. The learned counsel further submitted that the respondents authorities, for reasons best known, are trying their best to grant the contract to the private respondent. And this aspect of the matter can be seen from the fact that a plea has been adopted to reject the objection on the ground that the petitioner did not object within 7 days from the date of opening the technical documents, technical bid. The learned counsel submitted that immediately, learned counsel submitted that this is a case where there is a fraud being committed by the respondent. Now, this is a case which will come within the ambit of fraudulent practice adopted by the private respondent, having not disclosed vital documents which would have been necessary for the purpose of taking into account as to by ascertaining what is the available bid capacity. He therefore submitted that the rejection of the objection raised by the petitioner itself amounts to malice in law, for which the impugn actions on the part of the respondent authorities are required to be interfered with. Anything more? I said more than that. More than that. Mr. So-and-so, the learned counsel who represents the petitioner, submitted that the respondent authorities waive your clause whereby objections are to be filed within 1 month. No, as per him, his case. His case.
75, my lord.
Huh?
75, page 75.
When the parties go to the division bench, let them also have some problem. That is why both the matters are taken up together. The division bench also would have, where's the objection, raising of objection in your case?
My lord,
Technical objection, when can you raise? You have to raise that, na?
my lord.
Because that is your plus point. Ah, yeah. There's no provision here.
I checked other ways, my lord.
Can you come to page 81?
Not find it. 51.
It is not there, my lord.
Hmm?
Definition of words.
But my lord, so far as this particular clause of raising objection, that part one, my lord, held up in the other case. my lord.
No, will help.
So if,
Because nobody raised objection, na?
no, that instruction is not there, but we have, he has, on his own, he has stated in the para 12 of the writ petition that, my lord, just because he has not disclosed it, it has been rejected.
That's good. We can.
There may not be any complaint, but we, on our own, we may know, my lord, later on. The fact remains that, my lord, it has not been disclosed.
Non-disclosure also not affected my financial ability, my lord. Means if the second work, my lord, calculated, I have still, my lord, I am able
Huh?
to. My lord, non-disclosure of that suppression of that ongoing work, my lord, will not also, my lord,
I've seen it. Yes, letter I've read it, na? Mention about 16 line.
my lord.
Mr. So-and-so, the learned counsel appearing on behalf of the writ petitioner in WPC number so-and-so, 5969/2025, submitted that what was required in terms with clause
Yesterday, we have discussed about the page
4.7 is the value of the existing commitments and ongoing works to be completed during the next 24 months.
My lord.
Full stop. The petitioner had in terms with section 2 had duly mentioned about the work which the petitioner was certain would be completed within the next 24 months.
My lord.
And have intentionally not mentioned the other work pertaining to construction of the, what is that?
Girls hostel, my lord, at Janata College. That is, I have also annexed, my lord.
Of
Page 43, my lord, your lordship.
of the girls' hostel, bracket G+2 at Janata College, Kabuganj, on the ground that there was no certainty that the work would be completed within 24 months.
My lord.
The learned counsel submitted that though the petitioner had been issued a notice to proceed dated 16/6/2025 in respect to the said work, but the physical progress of the said work have not started. on account of the lack of architectural drawings and even after 3 months, the architect on the ground of non-finalization of the architectural drawings and the site being not handed over.
My lord.
He therefore submitted. The learned counsel further submitted. That the respondents herein were very much aware of this contract and then also have held that the petitioner was technically competent in terms which technically responsive in terms which the technical evaluation carried out on 18/8/2025, which was subsequently uploaded on 21/8/2025. The learned counsel further submitted that thereupon also the respondent authority have issued notice for did not receive any objection, the respondent authorities did not receive any objections from any quarters and opened the financial bid. The learned counsel submitted that on coming to learn that the petitioner was the lowest bidder, these steps are being taken now, almost after 1 month, by issuance of a communication on 15/9,
My lord.
15/9, alleging suppression of materials
Right.
of the existing commitment. Full stop. The learned counsel further submits that when there was a notice being given intimating about the suppression, about asking the petitioner to submit a reply, it was incumbent upon the respondents to pass an order rather than go ahead with the cancellation of the tender and issuance of the tender. That's your submission.
My lord.
Mr. B. Gogoi, the learned counsel appearing on behalf, additional advocate general appearing on behalf of the respondent submitted that though this court have taken up both the matters together, though the writ petitions 5163, 5164, and 5165 of 2020 and 5696, 5969/2025 have been taken up together. But the tendering authority in the case of WPC number 5163, 5164, and 5165/2025 and WPC number 5969/2025 are different. He therefore submitted that each tendering authority have a different perspective while analyzing the terms and conditions of the notice inviting tender. The learned counsel further submitted that the petitioner could not have filed the instant writ petition agitating the grievance as regards the technical responsiveness of the respondent, private respondent, on the ground that the same was not done so, and on the ground that the objection was not filed within the period as stipulated in clause 23.5 of the instruction to the bidders. He further submitted, even assuming for argument's sake, the petitioner can be held to be, can be said to be person agreed, then also the non-disclosure of the existing commitment by the private respondent would not have materially changed the available bid capacity, and as such have not, and as such would not result in any difference had the petitioner, even had the private respondent even had disclosed the existing commitment. Anything more?
And so far as this clause 23.5.
That's it.
Otherwise, we misunderstand. Basic stand is this within 7 days, it was not, the complaint was not lost, so now.
Mr. So-and-so, the learned counsel, insofar as the other repetition is concerned, what is your instruction? 5.6, 5.9,
There,
5.9.6?
no, there was in the motion stage, but even then, my lord, my submission will be. Page 44, in the notice to proceed with the work. Here, my lord, the performance security has been deposited, contract already signed. Between the PWD as well as the petitioner. So to say that, my lord, since my lord, the allotment of land has not been made, designed.
It is material.
That's why, my lord, the contract was already signed before issuing the notice to proceed with the work. That is my humble sir. He was supposed to disclose the same under the heading, my lord, commitment, existing commitment. There are two parts, existing commitment and ongoing works. So,
Insofar as WPC number 5969/2025, the learned counsel, the learned additional advocate general submitted that from the materials on record as would be seen from materials on record as would be seen from the enclosures, the petition being an annexure
annexure 11, page 44.
annexure 10, 11, 12, and 13. 13. It would be seen. When did you submit the bid?
2025. That is there, my lord, at page 43, your lordship, annex 10.
When did you submit the bid?
2025.
30?
To the 30th January, my lord.
No, here, in this case.
This,
You submitted, it couldn't have been, it was issued on 27/5.
my lord, your lordship, kindly peruse page 43. Page 43. 43.
No, this notice implementing tender is of 24th of June, then how can you do it on? You must have submitted prior to 28/7/2025.
We have submitted our bid
We
in
not-
this case, my
last
lord,
date
on
was
28/7/2025.
28/7.
28/7.
The learned counsel appearing on the additional advocate general, reference to enclosure,
My lord, I refer to specifically to annexure 11. page
annexure
44.
10 and 11, na?
Yes, 10 and 11.
10 and 11. Referring to annexure 10 and 11 submitted. That the notice that the petitioner herein having been issued a letter of acceptance and the notice to proceed with the work prior to even prior to the submission of the tender on 28/7/2025, the non-submission of the non-mentioning of this existing commitment amounts to violation, amounts to infraction to the mandate of clause
4.7 in this case.
4.7 of the instruction to the bidders read with
Page 96.
Section 2 of the bid document. He submitted that the non-disclosure of the bid document of the existing, all the existing commitments of the petitioner amounts to suppression of material facts for which the respondent authorities have rightly, therefore, rejected the explanation and gone ahead with a fresh tender process. Mr. So-and-so, the learned counsel who represents the private respondents in WPC number 5163, 5164 and 5165 submitted that the bidder, that the respondent number 4 had duly submitted the bid. Now, while submitting the bid, it completely escaped the attention of the respondent number 4 about the contract pertaining to the construction of the bungalow, inspection bungalow at Mongoldoi. He, however, submitted that this non-submission of the same could not have materially impacted the available bid capacity, in as much as the available bid capacity of the private respondent was around 41 crores in terms with the formula mentioned in clause 4.4, and even subtracting the amount pertaining to the contract for construction of the inspection bungalow, the private respondent still would have more than 40 crores. He therefore submitted that as the private respondent is the lowest bidder, the question of interference with the tender process should not be made. I've heard the learned counsels appearing on behalf of the parties and have given my anxious consideration to the materials on record, including the records which have been placed before this court. In respect to the notice inviting tender dated 21, first case, 21/6, no?
Lordship 21/6/2025.
21/6.
21.
In respect to the notice inviting tender dated 21/6/2025, which is the subject matter of the three repetitions being 5163, 5164, and 5165. It is seen that the petitioner herein, it is seen that the respondent herein, private respondent herein, admittedly did not provide the existing commitment This court further have duly taken note of, also have perused the reports as have been produced by the learned additional advocate general in respect to the three packages, which is the subject matter of the three petitions. In the technical evaluation so carried out, it is further seen that the petitioner, in the evaluation which is being carried out, it is seen that the tendering authority did not consider, did not take into account what while arriving at the tendering authority, while arriving at the available bid capacity, did not take into account the contract, the existing commitments of the private respondent. And it was only after the objection having been raised by the petitioner about non-compliance with clause 4.3 capital B of the ITP, read with section 3 of the bid document, that the respondents' authorities took into consideration that the private respondent did not disclose the existing commitment. This court further finds it very relevant to observe that on one hand, the additional advocate general, appearing on behalf of the PWD authorities, state that the petitioners in petitioner in WPC number 5163, 5164, and 5165 could not have assailed the technical responsiveness of the private respondent on the ground that the private respondent did not object within 7 days, on the ground that the petitioner did not object within 7 days. On the other hand, the same delivery authority have deprived the petitioner in WPC number 5969/2025 on the ground of not disclosing the second existing contract. This court further finds it very pertinent. This court further finds it also pertinent to observe that clause 4.4 of the notice inviting tender dated of the instruction to the bidders of the notice inviting tender dated 21/6/2025 and Clause 4.7 of the notice inviting tender dated, what is your notice inviting? tender? Of the instructions to the bidders of the notice for inviting tender dated
24/6/2025.
24/6/2025. Appears to be paramaterial. Except the fact that in clause 4.4 of the ITB in respect to the NIT dated 21/6/2025, the multiplication factor is 2.5, whereas in clause 4.7 of the ITB of the notice inviting tender dated 24/6/2025, it is the multiplication factor is 2. In the case of the petitioner in WPC number 5969/2025, if the contract value of around 12 lakhs, 12 lakhs, na?
Contract value is, my lord,
12 lakh 72,000, isn't it? How much?
bid value at 2 crore 80 lakhs, my lord.
Huh?
2 crore 80 lakhs.
No. See the contract, annexure 10 of your writ petition.
2 crore 54 lakhs.
2 crore 54 lakhs.
Of
2 crore 54 lakhs 49,099.
which one?
Of
For
the
Janata
one
College.
that he has not disclosed.
2 crore.
Yes, 2 crores 54 lakhs.
Even then, I have financial capacity, my lord.
2 crores 54 lakhs. And how much was this?
Present one, my lord, 2 crore.
Huh?
The otherwise the main tender was 280.36 lakh.
No. How much was his bid capacity otherwise?
282, my lord.
Huh?
2 crore 82 lakhs, my lord.
If you had disclosed that minus there, how much it would have been? Would
Minus,
that
my lord,
have impacted it?
I have calculated, my lord.
How much was your A?
1 crore 40 lakhs, my lord.
Then he will not come in well.
1 crore 40 lakhs, my lord. Minus. Out of 282, my lord. Out of 282. That is the bid value, my lord. And that is there in the technical bid also, my lord.
Mr. Counsel, what is A? At per clause page 74?
Why not? He has not mentioned the bid capacity.
Page
That
70.
calculation is not there. The petition is there, my-
Annual turnover, my lord, that is interested.
How much was it?
My lord, that is there, my lord, in the technical bid, my lord.
You must have submitted that document, now. Where is that document?
That is there.
Where is that?
Page 170, 170. Qualification information.
Total value of so and so last 5 years. It is much more.
Much more.
Page 170. And this will be multiplied by into n into multiplied by 2.
2, my lord. Then I have, my lord, that simple arithmetic. I have done.
That's simple arithmetic. So you have to take how many years? 5 years?
5 years.
Five
I bet my
years?
lord, last one is my lord, 3 crores 97 lakhs 81,593. That is in respect of
You take it
2023,
from 2020, 21.
No, my lord, 23, 24 I have taken.
But you have to take from which year? 2000?
2016, 17, that is there in page 170.
No, you can't take it from 16, 17.
17, 18, 18, 19, 20, 21, 20, 21, 21,
You
20.
can't take it from 16, 17. You
Last
have to
7
take
years,
it
my lord.
maximum value of the civil engineering executed during the last 3 years, updated to the price level. This is how you have to do it.
Last 3 years, yes.
So
Last 3
this
years,
is
my lord.
last 3 years will be, therefore he has taken.
My lord,
Last 3 years will be 2022,
23, 21, 22,
23, 24.
23, 24. I have taken that value, my
22,
lord.
23. Therefore, this is there. Therefore, he has taken 6 lakh.
My
6 crore. Then you are to therefore these
have-
two 170, the 2 pages 2022, 23, 23, 24 has to be taken, isn't it?
Last years, of course, my lord, not 24, 25, but prior to that, my lord.
So it will be 22, 23,
Yes.
23, 24. 21, 22, you can't take it.
No, 21, 22, 22, 23, 23, 24. 3 years that it will be 3 years.
The last 3 years from 24, we are in 2024, 25. 25, 26 now.
Now 25, 26.
So they will have to take from 22, 23.
Yes.
22, 23, 23, 24,
23,
24,
24,
25. So that will be the last 3 years.
24, 25. Yes, if it is June, my lord, then 24, 25 will come in. Yes, fine.
So
Yes.
it will be 24. So it has to be taken from 22, 23.
22, 23, 23, 24, 24, 25. Yes.
So
From 22
therefore you have to take only 3 crores and 3 crores 97 as per 170. So this amount, you have to multiply it by,
Into 2, my lord.
huh?
Into 2.
No, into how many years?
N is number of years prescribed for completion of the work for which bids are invited. N.
And then multiply,
By
N is, and then multiply by 2
By
minus B.
minus.
Then, and you minus, then this is of this current year, so you don't multiply by 1.5.
My lord.
So you, of this current year, so you divide, minus these 2. Then do you have the available bid capacity? Find it out at 2, give it to me. Have you understood?
My lord,
Very difficult to, I made him, you should have multiplied this 3 crores
my lord.
in 2022, 23
My lord.
into the present day. And then also 22, 23, you have to multiply again to the present day. After that, you get a particular value. After getting that value, you have to multiply it into the number of years. Then you have to again multiply by 2. And then minus it with this 1 crore and 2 crores. That is how you arrived at.
Lord, she will only record his statement that otherwise also, my lord, if that is included, he has the.
That is what I am going to do. Otherwise, it becomes very
If you can-
difficult.
Yeah.
Yeah. Very difficult. You have not understood. Yes, की line लिख ले राजू. Even if the contract value of both the contracts, which are the current commitments, existing commitments are taken, then also the petitioner has the available bid capacity. The above specs therefore show that the same department, that is the PWD, in its different branches, while applying the same condition, have used different yardsticks. It may not be out of place now to further take note of clause 4.3 capital B, which have been already quoted of the notice of the invitation of bid to the invitation of bid of the notice inviting tender dated 21/6/2025, which categorically mandates that if the documents which are required to be submitted in terms with section 3 of the bid document is not submitted, the bid would be non-responsive. Further to that, a perusal of clause 1.4 D, Roman 2, B, 1.4. One point four B, Roman 1 of section 3 of the bid document in respect to the notice inviting tender dated 21/6/2025 also mandates that the certificates from the engineer in charge of the rank of executive engineer or equivalent, and also the supply original or certified copy of the certificate in physical form envelope is a requirement. The question therefore arises as to whether this court should exercise its powers of judicial review, taking into account the settled principles of law in the case of Chief Constable of North Wales Police versus Events, reported in 1982 3 All England Reports 141, the House of Lords observed that the purpose of judicial review is to ensure that the individual receives fair treatment and not to ensure that the authority comma, after according fair treatment, comma, reaches on a matter which it is authorized or enjoined by law to decide for itself a conclusion which is correct in the eyes of the court. Following the said judgment of the House of Lords, the Supreme Court in the case of Sterling Computers Limited versus MNN Publication Limited reported in 1993 1 SEC 455 observed that if the contract has been entered into without ignoring the procedure which can be said to be basic in nature, and after an objective consideration of different options available, taking into account the interest of the state and the public, that the court cannot act as an appellate authority by substituting its opinion in respect of selections made for entering into such contracts. The Supreme Court further observed in the said judgment, but that once the procedure adopted by an authority for the purpose of entering into a contract is held to be against the mandate of Article 14 of the Constitution, the courts cannot ignore such actions, saying that the authorities concerned must have some latitude or liberty in contractual matters, and any interference by the court amounts to encroachment on the exclusive right of the executive to take such decision. In B.S.N. Joshi and Sons Limited versus Nair Coal Services Limited, the Supreme Court summarized the scope of judicial review and interference of the Supreme Court, of the superior courts in matters of award of contracts. Paragraph 65 and 66 of the said judgment being relevant are reproduced hereunder. This court also cannot while taking up the above judgments, this court also finds it pertinent to take note of the judgment of the Supreme Court in the case of Ramanna Dayaram Sethi versus International Airport Authority of India, reported in 1979 3 SCC 489, wherein the Supreme Court observed in uncategorical terms that the terms of the NIT cannot be ignored as being redundant or superfluous. They must be given a meaning and the necessary significance. In the case of Municipal Corporation, Ujjain versus DVG India Limited, reported in 2018, 5 SCC 462, the Supreme Court was dealing with the issue pertaining to the Supreme Court inter alia was dealing with the issue pertaining to the responsiveness to the tender and submissions. First, in the same case, comma, the respondent number 1 left out in the column blank, left the column pertaining to information pertaining to show cause notices blank. The respondent number 1's bid was accordingly evaluated at marks 5 with mark 5 with 5 marks, which was, however, increased by the learned High Court to 10. First, the Supreme Court, while adjudicating the said issue, observed that when in the tender it was clearly stated that the tenderer was required to reveal the show cause notices against it, and despite the specific column pertaining to the same in the bid document, the respondent number 1 kept it blank. The respondent authorities, the concerned tendering authorities were justified in awarding 5 marks, and the learned High Court was not justified in increasing the marks to 10. Paragraph number 55 and 56 being relevant is reproduced hereunder. In the backdrop of the above law laid down, it is pertinent to observe that clause 4.3, clause 4 of the instruction to the bidders of the notice inviting tender dated 21/6/2025. Now, clause 4.3b of the instruction to the bidders of the notice inviting tender dated 21/6/2025 categorically mentioned that there is a requirement for filing an affidavit in a stamp paper that the information furnished with the bid document is correct in all respects, and also to enclose the certificates as defined in section 3 of the bid document. It categorically further mandated that a failure to submit the certificates / documents as specified shall make the bid non-responsive. It is seen that the petitioner, the respondent, the private respondent, had submitted the bid document in respect to all the 3 packages without disclosing that he had entered into an agreement for construction of the inspection bungalow cum conference hall bracket G+1 at Mongoldoy bypass under contingency provision of job number 15 bracket /AS /2021-22/234 under PWD Rongia NH Division Rongia in the state of Assam. There was also no disclosure of the same in the affidavit so filed. Under such circumstances, in that perspective, if this court now takes note of the judgment of the Supreme Court in the case of Municipal Corporation Ujjain Supra and the principles laid down therein, and applied to the present case, it would be seen that when the notice inviting, when the bid documents mandatorily made it clear, categorically made it clear to provide such information, in terms with clause 4.3 capital B, and that too by filing an affidavit, and in the form mentioned in clause 1.4 B of section 3 of the bid document, the respondents ought to have, upon coming to learn about such suppression of facts, suppression of the contract or of the contract existing commitment, ought to have rejected the bid of the petitioner, of the private respondent. This court have duly perused the records as was produced by Mr. B. Gogoi, the learned additional Advocate General, wherein in the technical evaluation it is being seen that while arriving at the value pertaining to the available bid capacity, the existing commitment of the private respondent was not taken into consideration. And in fact, this aspect is apparent from the very stand of the respondent authorities, that they were not aware of till the petitioner submitted the objection. Under such circumstances, instead of going into the technicality of rejecting the objection of the petitioner on the ground of not submitting the objection within 7 days, the respondent authority, it would have been more appropriate on the part of the respondent authority to have taken action against the respondent number 4, against the private respondent, who have not disclosed the aspect which has a bearing on which has a bearing on arriving at what is the available bid capacity. This court further takes note of the submission made by Mr. B. Gogoi, the learned counsel appearing on behalf of the learned additional Advocate General, as well as Mr. So-and-so, who represents the respondent, private respondent, that even if the said bid value, said contract, existing commitment would have been taken into consideration, then also the respondent, private respondent, would have had the available bid capacity. No doubt, the respondent authorities have the authority to deviate from certain terms and conditions in public interest. But the question arises as to whether such deviation is permissible. Thereby, doing so only after coming to learn about the financial bid. Whether such deviation is permissible. facts of the case in WPC number 5969/2025. On the other hand, show that the respondent PWD department, as per their whims and caprice, deviates from the essential terms and conditions of the contract of the tender document, inasmuch as, insofar as the case of the petition, private respondent in WPC number 5163, 5164, and 5165, the PWD department have taken a different stand to that of the stand which they have taken in the case of the writ petitioner in WPC number 5969/2025. The above acts on the part of the PWD authorities, therefore, smacks of arbitrariness and violates the mandate of fair treatment, thereby infringing upon the fundamental rights under Article 14 of the Constitution. The above acts on the part of the PWD authorities in therefore continuing to hold the private respondent in WPC number so and so and so and so so and so as technically responsive, therefore smacks of arbitrariness, violates the mandate of fair treatment, and thereby infringes upon Article 14 of the Constitution. This court further is of the view that the petitioner in WPC number 5969/2025, having not disclosed the contract, the existing all its existing commitments, that is the contract pertaining to
Construction of girls hostel, my lord, advice করতে চাই।
construction of girls hostel (G+2) at Janata College, Kabuganj, have also violated the terms of clause 4.7 of the note of the instruction to the bidders of the notice inviting tender dated 24/6/2025. And as such, it is therefore the opinion of this court that the respondent authorities were therefore justified in rejecting the bid of the petitioner in WPC number 5969/2025 and going for fresh tender. Accordingly, all these four petitions stands disposed of with the following observations and directions. Number one, WPC number so and so 5163/2025 the decision of the bid evaluation committee dated 26/8/2025, wherein the bid of the respondent number 4 was evaluated as L1 bid for the work for the work maintenance of so and so if prior to silence is set aside and quashed. in the respondents would be at liberty to take such course of action as permissible under law, if so advised, against the private respondent. In WPC number so and so, এনেকুৱা হ'ব, is set aside and quashed. Same date, na? Bid evaluation.
Same date, Lord.
Okay, to contract to DD. Set aside and quashed, or A to any. Number two. Number in WPC number so and so. Set aside and quashed, yeah. Respondents are, authorities are given the liberty to take such action as per in accordance. The respondent authorities are given the liberty to take such course of action as deemed fit in accordance. Eighth repetition of in depth. The repetition, this court does not find any merit in WPC number 5969/2025, and accordingly the said repetition stands dismissed.
Lordship, one final
Not to
query.
give you, I cannot.
5969, it has been written, cancelled.
Therefore, I am saying dismissed. Therefore, I said he helped him. I can't give you. I told your senior Mr. R.N. Decker,
Lordship.
I am not going to. The records to produce are returned. You can go ahead with this decision. I think the order will come up on in 2 days. It would be difficult. It won't get so uploaded so early. But you can go ahead. As regards him dismissed and here cancelled. I have decision for bid evaluation and bid evaluation is done subsequently, na? I'm not touching on the technical bid. Technical bid was done when?
9th.
So 19A, the technical,
Bid.
the decision of the technical evaluation committee, na?
Yes,
Bid evaluation.
The bid evaluation committee or the technical evaluation?
no, it is the minute of the technical evaluation committee. Technical bid evaluation committee was held on 19/8/25.
19/8/2025, na? The technical, the technical evaluation committee, the decision of the technical evaluation committee dated 19/8/2025 to hold the private respondent number 4 as technically responsive is set aside and quashed in WPC number so and so, huh? In WPC number 1, technical responsibility, to hold the demand in respect to contract number, contract bearing, in respect to the contract for so and so utility. The bid evaluation, the decision of the bid evaluation committee dated 26/8, na? 26/8. You have challenged that 26/8, na?
Financial, that is the financial.
Financial.
That is the bid evaluation
done.
dated 26/8/2025 is set aside for maintenance. Itu etate দিব, ha?
No.
এনেকে heading di দিব, dispose of as follows. উপর দিব WPC number 5163 আর দিব the technical bid so and so into এনেকে হয়. Bid evaluation committee man, the respondents are directed to take steps as in accordance, are at liberty to take steps in accordance with law. Number 2 to heneke dibo, number 3 to dibo, and number 4 to khali upor heading, talat, writ petition stands dismissed.
My lord, one observation that further proceeding of the my lord NIT dated 21/6, where my lord lordship has interfered with, will be my lord lordship will if the liberty to
Therefore,
the
no, I've said
take
the
it as part of-
respondents are therefore are at liberty to take such action as per law.
Yes, it's not only against the my lord respondent of 4, but.
No, I'm
regarding
not,
the
I'm not saying anything against respondent because that won't be proper. That relief I'm rejecting. Why should I say anything? He has done it, he must have forgotten it, whatever may.
Right.
Because the moment I say so,
Yes.
he will be leading to blacklisting, which I don't want. So that is only remains. with that.
Item one for admission
So you therefore,
at two P M.
therefore I'm holding the technical evaluation insofar as the technical responsiveness of the unit is set. I'm not set aside the technical, otherwise the evaluation.
However, one observation, Your Lordship, the nomenclature of the technical evaluation, it is bid evaluation committee on technical ground. It
Bid
has been mentioned
evaluation committee on technical,
on technical ground.
the technical evaluation made on
Bid evaluation.
by the bid evaluation committee. Only. The technical evaluation made on by the bid evaluation
Bid evaluation
committee on so and so is insofar as the response number so and so is set. Number two, hold the financial evaluation made by the bid evaluation committee dated so and so is set aside. Yes, Manipur Industrial Development Corporation.
We don't have the so-called notice regarding the blacklisting, madam. I have only one so-called notice, that is 224 page number. That is.
My question is very
No,
simple.
madam.
Better over, you cannot, you go ahead, blacklisting, if you want to do it, do it.
Yes, madam.
But the issue
But
notice,
That observation.
as regards termination, he has nothing.
Yes, madam.
You will go before the arbitration. So only thing is as regards the blacklisting,
Yes.
you have to follow the due course.
That's all.
Liberty may be.
Better over.
That's part. Only that.
And liberty way to take.
Definitely, I am giving you the liberty. There's no,
Yes.
Mr. Your name is Paunam.
Yes, madam.
Mr. Paunam, do you have any judgment? The last time you showed me one judgment. No, it's not so much.
First, there, I think that Gurkha case, there are the 24, 25 also, 22 also.
Only one judgment will do where it
Yes.
is necessary that we have to.
Well,
issue
please
notice,
refer to,
and also that the blacklisting is for a particular year, period. It cannot be for indefinite.
Yes.
These are the two things.
Lordship, serial number 6.
Hello, this will
Gurkha.
help me in other matters.
Yes, madam. Compilation law, of course, Lordship, I am with sufficient that in the memorandum of understanding, there is a condition providing about the blacklisting only penalization from 1 to 10. But Supreme Court in some cases that even though it is not there in the condition of the agreement, it is inherent on the employer.
No, there's no quarrel. No, there's no quarrel with that.
Yeah.
I just need one judgment to make it look nice. Otherwise, there's nothing. The law is very.
That number 6 will do, Gurkha, my lord.
Huh?
Gurkha,
Which one? Gurkha security?
yes. That is followed in 2021 also.
Only one judgment will do.
Yes.
What are the
PMC
parameters
technology,
say there?
2021 is very clear also.
Rega? Common part, it's a common case of the parties that blacklisting has to be preceded by a so-called notice. Law in this regard is firmly grounded and does not demand any. This is one.
Lordship,
that
the
for
6,
such a
4,
area.
4
Be
also.
back in hand. Then paragraph 16, na?
Yes, madam.
Then, and where is that, that it cannot be for unlimited?
Lordship,
contents
that
of the
is,
so-called-
that will Lordship find at, that is at, my lord, Pulija,
Huh?
serial number 3, madam.
Page number?
Serial number 3.
Page. Pulija. Pulja.
Yes, madam.
Pulja, page 21. Pulja. You seem to be fond with all judgments of 2014.
Anyway, Lordship, I just pick up some authority and it's more convenient if I give an informed binding. That's why I done that. Right.
Let us not go into that aspect.
Ma-
I only go
I
to the
understand.
natural
I
justice
understand,
thing.
madam.
Because if I say now,
Yes.
let them do it again for a long period, again you come. Why should I close your avenue now?
And
Heard Mr. So the learned senior counsel, appearing on behalf of the, assisted by Mr. So who appeared on behalf of the petitioner. Ms. A. Gayan, the learned CGC, who appears on behalf of the Union of India, as well as on behalf of the respondent number 2 and 3.
yeah, right.
There is that 18.8.
It's number 110.
110?
Impugn,
21.
112, NSA 18,
Huh? 110?
A 18, my lord, 112. Page number 113, last paragraph is the. He hereby blacklisted with immediate effect.
No, this is being written by so and so. No, your termination.
Termination itself, lordship,
Where is your blacklisting?
it's him, it is together, man.
Huh?
It is the same order.
Where is your copy to?
Lordship, it is addressed to NG Roman, Managing Director, page number 112, NXA 18, my lord.
Okay.
18,
So you are Manipur Industrial Development Corporation.
Right.
Institute so-called notice followed by personal hearing afforded to MITL on demand to questionnaire so and so for committing violation and institute 1 month so-called notice demand which remain unanswered. Hereby blacklisted with immediate effect. Consequently, balance amount of balance of the petty So here we will only interfere as regards the blacklisting,
Right.
not the entire. The petitioner herein have essayed the communication dated 18/8/2025, whereby the contract with the petitioner was terminated and the petitioner was further blacklisted with immediate effect. Taking into account that there is an arbitration clause, no?
Yes, that is there.
Mr. So-and-so, the learned senior counsel appearing on behalf of the petitioner submitted that the challenge to the communication dated 18/8/2025 is limited to blacklisting of the petitioner only and not to the termination of the contract. As regards the learned senior counsel further submits that as regards the termination, the petitioner would take recourse to arbitration proceedings if so advised. In the backdrop of the above, the question therefore, in the backdrop of the above, it is the submission of the learned senior counsel that by the impugned communication dated 18/8/2025, the petitioner was blacklisted with immediate effect, that too, immediate effect, without any opportunity of hearing given to the petitioner. The learned senior counsel further submitted that blacklisting in the manner in which it has been sought to be done is contrary to the settled principles of law, inasmuch as the blacklisting cannot be for a period indefinite. In that regard, the learned senior counsel has placed before this court the judgments of the Supreme Court in the case of Gorkha Security Services versus Government bracket NCT of Delhi and others reported in 2014 9 SCC 105, as well as the judgment of the Supreme Court in the case of Purja Industries Limited versus Chief General Manager Western Telecom Project Bharat Sanchar Nigam Limited and others reported in 2014 14 SCC 731. It is seen that the respondents herein have duly filed their affidavit in opposition. On 17/10/2025, when the matter was taken up, this court, while passing the order, observed that the respondent authorities shall bring on record the affidavit indicating as to whether any proceedings were initiated prior to passing the order of blacklisting against the petitioner by giving the petitioner due notice. Ms. Akain, the learned counsel who appears on behalf of the respondent, submits with all fairness that the blacklisting of the petitioner, that blacklisting is permissible as per the terms of the contract. However, she submitted with all fairness that the said order of blacklisting was not preceded by any notice. Under such circumstances, the learned counsel appearing on behalf of the respondent submits that taking into account the judgments as referred to by the learned senior counsel appearing on behalf of the petitioner, this court, if interferes with the order of blacklisting, may give due opportunity, may give the liberty to the respondents to take action by following the due procedure. This court finds it very pertinent, upon hearing the learned counsels appearing on behalf of the parties, to take note of the judgment in the case of Gorkha Security Services, Supra, wherein the Supreme Court at paragraph number 16 and 20 categorically observed that there is a requirement of issuance of a show cause notice
Period 27, not 20, Mother. 27.
Huh?
Period 21, 20, 27 is clearly stated, ma'am.
that there is a requirement of issuance of a show cause notice prior to taking a decision to blacklist. In paragraph number 21 and paragraph 22 of the said judgment, the Supreme Court further emphasized what are the contents, what should be the contents of the show cause notice. Taking into account the above, this court finds it pertinent to refer to reproduce paragraph 16, 20, 21, and 22.
That is 27, not
Huh?
22, 27. 27.
27, why do you want 27?
We therefore of the opinion that it was incumbent on the water department to start in the short course notice that competent authority intended to impose such a penalty of the blacklisting.
Not necessary. I think this will do.
Oh, yes, I'm sorry, madam.
20 will do and 21 and
That-
22. Considering the fact, admitted position, considering the admitted position, that the impugned order dated 18/8/2025, insofar as blacklisting of the petitioner was not preceded by any notice, it is therefore it is the opinion of this court that the blacklisting of the petitioner by the impugned order dated 18/8/2025 requires interference. It is also the opinion of this court that as this court has interfered with, is of the opinion to interfere with the order of blacklisting on the ground of not issuance of notice, not in issuance of show cause notice. It is also the opinion of this court that the respondent should be given liberty if so advised to take action in accordance with law. Considering the above, the instant writ petition therefore stands disposed of with the following observations and directions. The order of blacklisting by the communication dated 18/8/2025 is set aside and quashed. The respondents herein are given the liberty to take steps, if so advised to take steps for the setting aside of the order dated 18/8/2025 insofar as the blacklisting of the petitioner shall not preclude the respondents to initiate action for blacklisting of the petitioner, initiate and take action of blacklisting the petitioner by following the mandate as laid down by the Supreme Court in the case of Gorkha Securities Supra. Number 3, it is clarified that this court have not set aside the communication dated 18/8/2025 insofar as the termination of the contract. First, the petitioners herein would be at liberty to approach to take such recourse to the termination of the contract if so advised in accordance with law.
Petitioner as well as respondent because it is both way, my lord, arbitration parties.
He has terminated.
Right.
Why will they go?
Anyway, lord.
Yes, Bilwat.
Council for the other side is.
Where is the other side?
Yes, Kamla. One.
Yes.
No, Miller, this is against an award. There are so many points on the award. Miller, by elapse of time, those points have lost their relevance. The only thing is that whether the lockout is justified or not. Now, the lockout was resorted in the year 2010 and still it is continuing. This is one aspect.
What was held here? Lockout was justified.
Lockout was justified. The learned presiding officer was of the view that bill worth is a public utility service. And accordingly, so far the public utility service is concerned, when there is a strike of lockout, a notice of a consequence.
Only terms of reference is 11 remains.
Now, my lord, I shall.
Alleged breaches of law by management due to lockout declared by them in the factory establishment with effect from 8 AM of 5/10/2010.
Now I shall only place this thing. I shall place only this thing because the lockout was resorted in the year 2010. Now it is 2025. 15 years of elapsed. There are
Now, what is, if it is held now, that the lockout is illegal,
then we will get full wages during the period of lockout. And if it is held that lockout is legal, but prolonged lockout is unjustified. Prolonged lockout is unjustified because lockout is being continued for a period of 15 years. That is one of the aspects that requires to be considered by your lordship. And another thing is, my lord, the learned presiding officer.
So if the lockout means if they can't keep a lockout for industrial disputes, like lockout is permissible as temporary measure.
Where?
Lockout is permissible as temporary measure.
Virtually, if you allow this thing, then it amounts to a closure of the establishment. You have resorted lockout in the year 2010, and now it is still continued. It amounts to.
There will be requirement of replacement.
Oh, yes. If it is allowed to stand, then it is virtually closure of the establishment. Because lockout was resorted in the year 2010, it is still continuing. Now, in order to close down a establishment, you have to comply with certain provisions. At least you have to pay the retrenchment compensations. And that apart, this establishment has more than 100 workmen. And for that purpose, they are to obtain permission from the government to close down their establishment. Nothing has been done. And lockout is defined under section 2L. Very definition is lockout means the temporary closing of a place of employment. Temporary closing of a place of employment or suspension of work or the refusal by an employer to continue to employ any number of persons employed by him. Now there are certain conditions.
There are many things. Means the temporary closing of a place of employment or suspension of work or refusal by an employer to continue to employ any number of persons employed by
him.
So 3 of them.
Yeah.
So therefore, we have to go now to 22.
Now let your lordship come. The provisions of when a lockout shall be declared as illegal or when a strike shall be declared as illegal. For this purpose,
So we have to read first 22 and 23.
Milan,
Section 22, 23.
22, 23 and 24. Let us start from 22, Milord. No person, 22, prohibition of strikes and lockouts. No person employed in a public utility service. Milord, this is very much important.
No,
Public,
one is not, no employer. 22.2.
no,
We are concerned with 22.2 in the facts. We have nothing to do with 22.1.
yes, that can be done.
22.2.
Hmm. Yes, that can be done. No employer carrying on any public utility service shall lock out to his workmen without giving them a notice of lockout hereinafter provided within such and such. These are the conditions. Within 14 days, giving such notice before expiry of the date of the lockout specified in such notice during pendency of a conciliation proceeding before the conciliation officer and 7 days after the conclusion of such meeting. Now, Milord,
So if there is a strike, then the notice is exempt.
here, if there is a strike in a public utility, so there is a notice is required. 14 days notice.
Then no. The notice of lockout or strike under this section shall not be necessary where there is already in existence a strike.
Yes.
So if there is a strike, then there is
If,
no
no, if
requirement.
there is a illegal strike, then
No, it
the
doesn't
notice
say
of,
about illegal strike. If there is a strike, you don't require. Where does it say it to be illegal?
anyway, let us say if there is a strike, then required. Not required.
Or as the case may be, lockout in the public way. But
Notice
the
of strike
employer
referred to
shall
such and
send
such.
intimation of such lockout or strike on the day on which it is declared to such authority as may be specified by the appropriate government, either generally or for particular area or for particular government. A strike referred to in so and so shall not be given by such number of persons. The notice of lockout referred to here shall be given in such manner and prescribed. If on any day an employer received from any person employed by him.
Shall be given in such a manner as may pay. If on any day the employer receive a notice from any person employed by him, any such notices are referred to subsection 1 or gives any person employed by him to any notices as are referred to in subsection 2, he shall be within 5 days thereof report the appropriate government to such authority. Government may prescribe such notice received given by on that day. Probably Lordship. Notice of lockout or strike under this section shall not be necessary where.
But if we come to 24.2.
24, yes. That is important. Where a lockout, where a strike or lockout in pursuance of an industrial dispute has already commenced and is in existence, then the time of the reference of the dispute to a board, arbitrator, national tribunal or national tribunal, the continuance of such lockout shall not be deemed to be illegal.
provided that such strike or lockout was not at the commencement in contravention of the provisions of this act or the continuance thereof was not prohibited under it.
Yes.
So therefore, the present writ petition is a continuation.
Hmm.
So the continuation of the lockout for the last 15 years.
Whether it is justified or not.
No, unless at the initial time, if it is, the lockout is held to be illegal,
Illegal.
then it will be illegal now also.
No,
Yes.
Supreme Court decisions are there.
What did it say?
One decision. That is Supreme. Yeah, 1963. SC 575.
Yes, what did it say?
Let us read the paragraph 8. Coming to the next question, coming to the question of the lockout, is abundantly clear that the lockout was ordered by the company because of a sudden strike. No doubt, token one, launched by the workmen. It would appear that the strike was only to be a partial and notice was given on previous day. In order to appreciate the background of the strike and lockout, it is desirable to set out certain facts by an agreement dated 23/12/11/1956. The management has agreed to pay 37 days wages for its factory employees for the year 1956-57. Matter relates to the bonus, my lord. At that point of time, the payment of bonus act was not in force, my lord. Bonus. It was also agreed at that time that the bonus was not to be a condition of service. On 10/9/1958, the respondent union made demand for 7 days bonus over and above the usual bonus of 37 days. In reply to this, company stated in its letter dated such and such that it does not agree with the demand of the bonus. It is payable as a condition of service. That although no bonus is payable, the company, as a gesture of goodwill, have offered to pay the workmen 15 days consolidated wages as bonus and expressed the hope that its offer would be accepted. On 13/10/1958, the company agreed to wrote, company again wrote to the union pointing out that the workmen had resorted to go-slow tactics, which is adversely affected their business, which was repairing the ship and observed. We should also strongly suggest that the management and the union jointly approach the labor directorate at once on the following issues. Number one, whether the workmen are justified in stopping overtime and when they like, as and when they like. Number two, bonus. In consideration of this, we may even agree to pay the workmen certain sum of money as may be recommended by the conciliation officer on advance account pending the adjudication by the tribunal of this issue of bonus. It should be, however, be clearly understood that if the tribunal decides against the payment of bonus or allowance bonus less than amount advanced to them, the entire advance money or the difference will be recovered from the wages of the workmen by the installments as may be directed by the tribunal. This suggestion was preemptively.
Understood, but this is not the terms of the reference. You see, alleged breaches of law by the management due to lockout declared by him in the factory within here. Now you see the terms of the reference is as to whether the lockout is illegal or not.
Yes.
Now, the tribunal has held it to be not illegal.
Ah.
Okay. Now, the question is, The continuation of the
Yes.
lockout, whether it is justified. or not.
Initially, when the lockout was resorted, it may be illegal. But continuation of the lockout for prolonged period,
But that is not the terms of the reference.
whether lockout is justified or not.
No, therefore, the question is, if that be so, it has to be referred. It has to be, this court cannot sit over that. That is not the subject matter. I'm not sitting in 226 simpliciter that whether these people, whether the government not taking any action as regards the continuation of the lockout. That is not the
No,
subject
that is not the
matter
issue.
before us. So
That is not
therefore-
my case also, Blood.
So therefore, here, if the lockout is illegal initially, whether the lockout was illegal or not, that is the question.
Yes. No.
Yes.
Lockout is illegal. Initially, lockout is illegal. But long continuance of the
That is not the terms of the reference.
like every reference is made in this way.
Look into that. How can I look into the beyond that? I cannot look because I could have, if Mr. Dasgupta, the best option would have been getting this lockout okay, then you say that can you continue? Have another reference. That is what it could have been done. Think about, I'm coming in 5 minutes. Think, otherwise I'll.
So your lordship view is that if there is a illegal strike, then the employer can close down his establishment permanently.
No, that is not my look. My view is, if there is a lockout, which is legal or illegal, terms of
If there is a strike.
there is a strike or even, let us assume that there was a lockout,
Hmm.
wherein the legality or illegality is the subject matter of reference.
Yes.
The court, the labor court, if it holds it to be legal, and during the passage of time, the matter goes on,
Yes.
and a question arises as to whether the continuation of the illegal lockout
Or let
or
us,
the
cons-
legal lockout
let us consider it
was
legal labor.
justified
Yes.
is a question which will be a subject matter of a further reference. Because you see, my jurisdiction is limited.
Hmm.
I cannot exercise powers like the Supreme Court does under 141 or 142.
Court that too.
So my thing is, I'm only to look out here of a certiorari jurisdiction as to whether the order is right or wrong. But if it is a case that whether the continuation of the lockout is justified for the last 10 years or 15 years,
15 years, more than
15 years, whether it was justified or can it be prolonged is a reference that obviously the justification aspect can be looked into by this court under judicial review. But that is not the subject matter before me.
But I have come across a number of cases, whether the lockout is justified or not. Then while dealing with this aspect of this case, Supreme Court Supreme Court held, that yes, lockout was initially justified, but in course of time, as the lockout continued for a longer period, it became unjustified.
Absolutely unjustified. But,
But
that
the
is,
terms of
that is
reference
under
was not there.
142. You see, that is the problem I cannot exercise. I am taking the power in judicial review. The Supreme Court can very well say that.
I have come across a judgment of Honorable the High Court also.
Very good. Let me see. Because that cannot happen because my consider.
Yes, I have understood your.
That the labor court's judgment, the scope of interference is very limited. It is very limited. Unless I find there is a perversity or some evidence having not been taken into account.
Other problem.
Yes.
Other person, yes.
Yes.
Let us have some discussion on this. Yeah.
You see here, kindly see here, what is it? Whether terms of the reference, whether so-and-so and so-and-so and so-and-so are justified in demanding wages for the lockout period from
Yes.
so-and-so to so-and-so from the management and so-and-so. This is the terms of the reference. Now,
Whether the lockout was justified or not, that aspect was considered.
held that it was the conduct of the which brought the lockout and declared by the management, and therefore the lockout was justified in the beginning.
Yes,
The
beginning.
tribunal, however, held that though the lockout was illegal, legal in the initial stage when it was declared, it had become unjustified because of its long duration.
Yes.
The tribunal further held that the conduct on the part of the workers as well as the management was responsible for the sorry state of affairs and for the workers' unrest here.
There are other judgments are there also. That I can place it.
Finally, come to paragraph 14. Here, in this case, the tribunal held it to be not justified.
Hmm.
The issue was during that period.
Yes.
So the tribunal had the jurisdiction to look into this aspect or
No,
that.
initially, lockout was justified, but during long continuance of the lockout become unjustified.
So, no, the tribunal was put with the question as to whether they were entitled to these particular wages during the entire period from this period to that period.
Yes. I have some other judgments.
And the
also.
court held out there, the tribunal held that yes, for this particular initial period it was right and subsequently it is not
Yes.
proper.
There are other judgments of that.
But how do you take care of 24-2?
Yes.
How could the tribunal even hold that?
Now let us come 24-2.
Huh.
When a strike or lockout in pursuance of an industrial dispute has already commenced and in existence at the time of reference of the dispute to the board, labor court, national tribunal, the continuance of strike or lockout shall be deemed to be illegal.
Shall not be deemed to be illegal.
Shall not be deemed to be illegal, provided that such strike or lockout was not at its commencement in contravention of the provisions of this Act. Continuance thereof was not prohibited under subsection 3 of section 10, section 10 and subsection 4A of section 10A. Now, let here what happened, the learned presiding officer was of the notion that bill work is a public utility service. And when there is a strike, notice of strike in a public utility service, it is the duty of the conciliation officer to initiate a conciliation proceeding. And during the continuance of this conciliation proceeding, if the strike is resorted, then that strike will be declared as a illegal strike. And in consequence of that strike, the management acquires a right to resort lockout. That is easy. Now the basic question is that whether the bill work is a public utility service or not. That has to be looked into, below. For that purpose, your lordship come to the definition of public utility service. Section 2L.
Let us see on what basis it came to a finding that it is a public utility.
Oh, yes. One is here, lordship. Come to page 27. On several places, page 27. First, second paragraph 7.
We are concerned with 11, na?
Where
is the finding as big
At-
as 11?
At present, I am concerned with 11. Straight away, lordship, come to paragraph 7 of the award, page 27. I will go in detail later on, Lord. From the above situation, it is found that as per 11 issue number, the management committed illegality. From the above situation, it is found that management, issue number 11, that the management committed illegality or breach of industrial dispute law by declaring lockout in their factory establishment with effect from 8 AM of 5/8/2010. It is pending because of this notice of the conciliation. In this regard, it is found the evidence of MW1, MW2, WW1 and WW2, and from the exhibit 21, it is found that the workmen resorted to strike on 3/8/2010 during the time of running conciliation proceeding, dated 3/8/2010. And also from exhibit 24, exhibit 26 and exhibit 26/7, it is also found that the assistant lawyer commissioner declared that during proceeding of the conciliation, they resorted to strike. Exhibit 27 on conciliation also says so. So as per the law, if the conciliation proceeding is going on, however, the workman resorted to strike, it amounts to an illegality. In these regards, it is found that in the first schedule, that is very important. In this regard, it is found that the first schedule of the Industrial Dispute Act, serial number 9, Buildworth Private Limited is a public utility service, public utility industry. And as per section 2N plus 6, accordingly, as per section 22, it is clearly said that during the conciliation proceeding before the conciliation officer and after 7 days after the conclusion of such proceeding, the management or workmen cannot take any measure like lockout and strike, and as the case may be, even in the public utility service, without giving notice for 6 weeks, nobody can take resort to strike. Even it must not be within 14 days giving such notice. At the same time, employer also cannot declare lockout. From that point, it is found that the workmen resorted strike during the conciliation proceeding as a result that an assistant labor commissioner declared it illegal. As a result, that I have found that the workmen committed illegality by calling strike under section 24 of the IDA. Therefore, at the same time, I have found that the management can also follow the same procedure. However, if the situation is such that where there is an exigencies due to the strike, the management can declare lockout. Now this Millard, I shall refer to definition of public utility service. Lordship, please come. Section 2N. Now, the gist of the section 2N is that there are some service which shall be considered as a public utility service. Apart from that service, there are a large list of industries which can be declared as a public utility service. For that purpose, a notification is required. Public utility service, may I read that? Public utility service means any railway service or any transport service for carriage of
We are concerned with 6, N6.
N6, yes. Yes, N6. N6 is that any industry, apart from those industries, any industry specified in first schedule, which the appropriate government may, if satisfied that public emergency or public interest so requires, by notification in the official gazette, declared to be a public utility service for the purpose of this act for such period as may be specified in the notification. Not for all time, provided that the period so specified shall not in the first instance exceed 6 months, but may by a like notification be extended from time to time by any period not exceeding 6 months at any one time, if in the opinion of the appropriate government, public emergency or public interest requires such extension. Now, Your Lordship, come to Schedule 1. Serial number 7. Please. Industries which may be declared to be public utility services under subclause 6 of clause N of section 2. First, transport; second, banking; third, cement, etc. Fourth, coal; fifth, cotton, textile; fifth, foodstuff; 7 is iron and steel. So a special.
But Mr. Dasgupta, why should we go into public utility service? Yes, he has done so. See, 22 is for the purpose of public utility service. 23 is for any industry. 23 says, if there is a strike during the pendency of a conciliation proceeding before the board and 7 days after the conclusion of such proceeding, it will be an illegal strike. If it is an illegal strike, then they can go for a lockout.
But
So why
this,
should we go? Yes, the labor
his
court
finding
may
is
have
that.
gone into and said that it is a public utility service. But even if it is not a public utility service also, resort to lockout can be done in terms of 23 if there is an illegal strike.
Yes.
So therefore the question is,
Whether there is a conciliation proceeding or not.
so there is no doubt there was a conciliation proceeding. Fact is there. During the conciliation proceedings, there was a strike. That was another aspect. I'm not on there. But the only issue which, in my opinion, should have been that it should have been done at the earliest. It should have been done at the earliest is, should this lockout be permitted to have gone on for such a long period?
Yes.
The fact that there was a strike during conciliation proceedings is a finding of fact. I can't go into that. The Labour Court may have been wrong in holding it to be a public utility service, taking into account that without noting as to whether there was a notification by the appropriate government, it could not have gone into. But then also, any industrial establishment can go for a lockout if there is an illegal strike. So if that be so, if this had gone, but the question therefore is, could it have gone for such a long period? But that is again, the subject matter is outside my scope. Even in the judgment of the Andhra Pradesh High Court, the question the court was doing is after the termination of the lockout. So therefore, the reference is from this period to this period, whether they were entitled to the wages of lockout. So therefore, 24, when the industrial dispute arose, then 24(2) did not come into play in that case. In the case of Andhra Pradesh. But here the 24(2) will come into place because this was there at the time when the industrial dispute arose, the lockout was there. Whether it was illegal or legal, but it was legal. If it is a legal lockout, if it is pending during the pendency of the tribunal, cannot be held to be illegal. Or even unjustified. The answer is
No, it was not
question
pending.
does not arise in the concept of the Industrial Disputes Act, although the Supreme Court have dealt with and held it to be so in those judgments. Because there is no question of the Industrial Dispute Acts do not otherwise say as regards prolongation of a lockout.
Now, my lord, if it is this thing is allowed to be accepted, then virtually this establishment has been closed down.
Understood. So that is what I'm worried. What is to be done?
If it is closed, let us agree with this thing. If it is closed down, then the workmen are entitled to have their benefits under the closure compensation.
Therefore, the question is, should they have also taken the benefit of this long pendency?
Yes.
This matter has been pending for long. It should have been initially finished it off then only. If you hold it that it was lockout was bad or good or whatever may be, you should have finished it off. But the question, if there was a long prolongation, there should have been but then also you can file a 2A.
Two is the retrenchment compensation.
No, no,
After,
2A. Industrial dispute you can file.
only for retrenchment, only for illegal retrenchment.
Then the government has to go for no,
No.
that's illegally.
Illegal retrenchment and termination. We have not been retrenched yet. No? We have not been terminated over there. Some type of solution is required, my lord. That is
That is why
whether we strictly follow the law or not, some equitable concept should be.
But I cannot think over it. That is the big problem. In fact, that is the sad part of all labor court disputes. What is happening is the
So-
courts have admitted it, fixed it for hearing. It comes on its usual course. At the end of the day, even if you see the Industrial Disputes Act, the basic idea is to complete it as soon as possible.
Yes, yes.
But it is given, it takes the most time.
Dispute arose in the year 2010.
That is what.
Let me give some other judgment on some other day among Tuesday. I don't know whether you are fully here or not. You are fully here.
Let me think of what also can be done. I have due sympathy for your client, but the problem is my hands are tied. Yes,
Now,
Governor,
we have other issues
you are
also.
there. No, but- What about names? Names are there for, we are not concerned. We are concerned with you being the appropriate government. Would you have allowed this lockout to go on for such a long time? Isn't this the very serious? The reference was as regards legality or illegality, matter end. And the court have only issued notice here, there is no stay. So wouldn't that come within the ambit of an industrial dispute, the continuation of the lockout for such a long time? Because there, the question of whether long period should have been there, is it justified or not, is also a question of evidence. Mr. Raghuta, you also have to appreciate whether there was justification for continuation for the last 15 years is also a question of evidence.
No, yes, they can continue for more than 50 years also.
No, no, it's
So
also a
in
question of
such
evidence.
stage, it should be presumed that the establishment has been closed down.
Understood, but isn't it a question of evidence, this justification? It cannot be given just like this by this court. This court can't take up new evidence. Problem is, I'm not sitting in the original jurisdiction of 226 in this
So
matter.
your lordship may allow me some time on Monday or Tuesday. I will make it clear. I shall try to make it clear.
Saturday,
Saturday I have some problem in that.
make it clear on Saturday. We finish it up. That will finish the agony of these people so that they also get something. And we get their opinion. If the government is a party,
Your lordship is not, in the next week, your lordship is not here.
government is not a party. There the problem arises.
Monday, then he go.
Yes, sir, Saturday.
Because this court, if I ask them also,
I shall try to clarify your lordship by bringing some judgment in this land.
Hmm?
In this land, I shall try to bring some judgment.
chalo. Yes, so how long are you going to go for lockout?
Evidence also and the notice also.
What?
After the lockout,
Put it on the mic. There's a mic by here.
after the lockout, they have not come to tender their service.
They have
Not come to tender their service.
tender their service.
Yes, they have not come because from the illegal strike, they have not withdrawn the strike. Because one of the contention was if you withdraw the strike, we lift the lockout. But that has not happened. Be that as it may, what your lordship, yeah, that's why I requested this matter to go for mediation once. There was agreement to a certain extent on how much money, ultimately, how much money to pay. If your lordship is keeping on, say, Tuesday.
Why you not agreeing to something?
Yes, I am agreeable.
No, your people didn't agree in the.
No,
money.
they have, I don't know what is their
You
offer.
see, at the end of the day, the problem is the court again, these people will die off by the time
I am not
another.
standing in the,
Huh?
I am agreeable with any kind of settlement, but settlement should be fair.
No.
One thing, what I
What
personally,
is your settlement proposal?
what I personally feel, Millard, for all purposes, it should be considered a closed down establishment.
No,
Now they are
no,
not good.
You can, not on that. I'm not on that. What is your submission?
There was a proposal for.
What is your proposal?
That, there's a chart to decline. So if your lordship.
There's a report given by the media.
That chart won't be here, your lordship.
Huh?
That how much we are willing to pay, that chart, I think it won't be here.
No, what is your proposal?
That your lordship, I'll bring because we have prepared one with respect to each employee. How much payments are there, dues are there, everything.
No, there's a report being submitted. Where is
Yes.
the report? Hey,
That I
the
think
portion matter in pursuant according to
That's a
first
failure
hearing was
report,
held for the mediators to answer mediation. And let the report to demand the mediation is answered and return back. Nothing. Because if I dismiss your case, then finish.
That is why, your lordship, we wanted to pay them.
And pay and then what? Close down.
Close down that to aspect of.
Obviously, you are going to close down having not worked for 15
15
years.
years, see, the plant and machineries have gone wasted now. That's another aspect. However, in the meantime, because of the new master plan, the industrial activities are not allowed to be carried there. So now, point of consideration would be.
Closing down.
If at all, they are entitled to 25F.
Huh?
If at all they are entitled to some.
Closer
25F
compensation.
or closer compensation, it would be on the date of the illegal strike or when. We are ready to pay everything. And because if there's a 48 numbers of employees, that's a huge amount. But still, for their benefit, we are ready to pay.
Yeah, establishment is in the prime land.
But that's
It's a
industrial.
different thing, it's a prime land.
So now that time we are going through a huge financial crisis. So now, to be fair to them, we are ready to pay, but it's off the record. But they have not accepted that.
No, I don't understand why he is saying all this. If you want to pay the consolation, closer compensation, will definitely will agree. Because it is for all purpose, it should be considered that closed down. And even what my learned friend says that this is a zone where the industry
You
cannot
know
be
what?
carried out.
We'll have it on 111. Give your submission as regards what is your offer. Without
Miller,
prejudice,
Miller.
without prejudice.
Without really.
Miller, can it be on Monday, Miller?
We'll have it on Tuesday then. Let us hear
Yes,
it out.
yes, Tuesday, much better.
Otherwise, that is the
My
date
provision-
only for the purpose of mediation. If mediation by court, not by them.
Yes.
And if it is permissible to get this particular, and if you are agreeable, otherwise, Mr. Dasgupta, I'm saying you don't have a case.
One thing that
But
I
that
will,
should not be the reason why you should come down on your offer.
No.
this is what I propose, Miller.
It has to be,
Whatever the demands are concerned, let us forget all these things. Whatever they will pay, I shall try to convince them. Let us assume that this establishment has been closed down. 15 years lockout, that apart, they cannot carry out their business in this place because it is not an industrial zone. So if it is closed down, then all the employees are entitled to have their retrenchment compensation. Otherwise, again, I have to,
Retrenchment compensation is how much? 3 months?
no,
How
for
much?
every completion of year of service, 15 days salary.
15?
15 days salary. I am not at all adamant on these issues. Whatever they will pay, I shall try to convince them. But at least if they gave the retrenchment compensation, then
Mr. Sharma, another thing is, till this matter pending, you can't do anything to that property also.
yes.
Your client should also understand that. Till you don't do anything, you can't do anything to the property. And if you can't do anything to the property becomes valueless. And you must be having good intentions of doing something. This is the prime zone, isn't it? Near in the
Yes,
GS road.
actually, they made an attempt to sell it out. Yes, I should not discuss all these things.
That's a different thing. I'm not on it. But isn't it in the GS road?
Yes. Just
That's in
opposite,
the prime location near
just opposite
NEF
Apollo
college.
Hospital.
It's the prime location area.
Just opposite Apollo Hospital.
Ah.
In fact, Milord, Apollo Hospital probably approached them to purchase it.
That I don't know.
That we.
It is off the record, Milord.
But then also I'm saying you
and-
can try to come up with a good figure.
And
Good.
there was a talking.
People have also rendered, give some golden handshake and let them.
Yes. Whatever amount your lordship fix, I will waive it. I will leave it to your lordship.
So.
Whatever amount.
First, let's see your proposal without prejudice.
Without any bargaining.
Without prejudice.
Without any bargaining, whatever amount your lordship will fix, I will try.
I'm not going to say anything, but then we can finish it
At least
off
let
and
this-
say that, yeah, the matter can be resolved out there and then they are being given out there, they accept their, go for some form of AI, thereby accepting as per acceptable mode.
Yes.
By which you have a golden handshake and terminate their, or whatever may be, it will be a retrenchment which will be done and all this
Yes.
thing. And they accept this as the full and final settlement. And this court will record it and finish it off.
Yes.
This is the only way out.
Yes.
Instead of negotiating out there before the mediator, I think this is the only way out. And if that is done, it is better. Otherwise,
In fact, the.
At the end of the day, it is also not proper because this will lead to another litigation.
Yes.
And once there is a litigation, you cannot sell of anything.
Yes, yes.
Nobody will also like to purchase with a litigation. The value which you had to get 100, it will become 50.
Hmm.
That is the biggest hurdle in real estate also. Chalo.
Offer what?
List this matter on
Let it.
1/11/2025 as the third item in the list.
11.
Mr. R. Sharma, the learned counsel, appearing on behalf of the respondent.
First November, I have some.
You don't come, we'll hear. She's there, then I will, let us get the offer and then we'll have it on again third.
Lordship, can
Four-
you give
four.
four?
No, fourth, no, first.
First,
First is this and then fourth.
I'll
Ge-
give
You
one.
get it, today is Tuesday. Then you get the offer, that is what I'm saying. No, second is Sunday. On
Third.
first, as item number 3, I've already fixed 1, 2, this is the third, item number 3. As the third item in the list on which state Mr. R. Sharma, the learned counsel, for the respondent shall place the proposal without prejudice to the rights of the respondent.
Which starts on Friday or Friday.
Friday,
Yes, that can be done.
okay? At the top of the list.
Very good.
Let them give the proposal.
Let
We'll
it
see,
be,
then
let
we'll
it be,
have
let it be
clear
on Friday. Well, I have to go schedule. That is the problem. All right,
Mr. Dasgupta, we don't require you. If there is a hearing required, we'll have it. Let us know
Okay.
what the proposal is. And thereafter, I'll put it back to your junior. You come up on court.
Well,
Then whether you agree or not, if you don't agree, then this court takes up the final decision.
fast.
I don't keep matters like this pending for long.
Item 13.
It is only item number, the last item today was the item which is going on for a long time because of the CGC playing hide and seek. One matter. So it was taken as item number 1 today.
Oh, that is blacklisting matter.
It's a land matter which have been taken over by the CRP. So they are not admitting. So this is what happened. Otherwise, the matters needs to come to an end. Hello, we have it on when
Right.
31st.
Yeah.
31st.
Obliged, Lordship.
31st.
At the top of the list. Huh?
31st, no?
Only that, you just come up with
yes.
that and then we finish.
31st is 31st, no problem. I can do it.
31, the top of the list, and then we put the proposal to you. If you agree, otherwise,
31st, I'll be here.
but make the proposal reasonable.
Reason. In fact, Your Lordship, most of the workmen are accepted, apart from one. That's why it collapsed.
I don't know.
Let us,
But anyway, let's see.
we'll take care of.
Obliged.
Item 13, extended to PM.
Is it? Oh, yes, where's your license? It has been renewed. This is the name of your license.
Name of the license is Shankar Kalita. This was the proposal, first page number 1 is the proposal made for 2025 and 26 current year. Then
You're off license, huh?
Off license.
off license.
The name is Sanjeev.
Shankar Kalita.
Where is it? Serial number?
Page 21, serial number 41.
On full court, Hatigaon.
Hategaon. Then your honor may refer to page 32,
It has been renewed for 1 year.
1 year. My lord may refer to page 32. It's for 2025-26. amount is being paid. Then 33 last year, 24-25. And the last page,
So the
23-24.
one full is where? Hathigaon.
Hathigaon.
So prayer number 3. You want compensation also?
No, Your Honor. Compensation was actually sorted from the Mahila Samiti. Actually, the entire process started because of a complaint filed by a Mahila Samiti. And my lord may see the Mahila Samiti that has filed the complaint is at a distance of 700 to 800 meters from the shop.
So you are renewing it.
We are renewing it. The
Then-
thing is that we are not against his renewal. We are just asking him to shift from the current location to other locations.
Why?
Because there are complaints, 75 meters, he says there are 24 residents, 18 have given no objections, 6 have given objections to that. So that's, and may I take to the TPN order, Your Lordship, which they are challenging.
Yeah,
It-
Mr.
it's-
Homi, I won't take up your matter. Oh, but it will be shown as leftover.
I would have been highly obliged if your lordship had taken it up. I would have been highly obliged if your lordship had taken it up, because I want.
Take it up.
Yes.
Okay, then I'll take it up. Don't worry.
At page 68.
I was saying that I won't take it up. You don't want the matter to be
No,
taken
no,
up.
I wanted to accommodate KP Pathak because his
Oh,
father,
that is why. Oh, that is why.
his father is unwell.
That I know. So, okay, I won't take it up. Don't worry.
Your
But
lordship
it will
may
be
kindly
shown as
fix-
leftover.
Your lordship may kindly fix a date. I want this to be finished. It's a 2017 matter.
2017 APDCL, it doesn't. You are also APDCL council.
Yes, Your Lord.
So next time you appear in that matter, item number so and so. Because of the fact that he has difficulties, the cost of Pathak.
Yes.
some profit. We understand that, so pick it up on some other day. 2017 APDCL matter it doesn't look. People, the government.
If your
will-
lordship fixes
APDCL
a-
think that the High Court is dealing them.
If your lordship fixes a date, I would be highly obliged.
Okay, when do you want it?
Any date, apart from,
Convenient, Lordship. I'll take the brief from you.
apart from 13,
It has
14.
been submitted by Mr. K.P. Pathak, the learned standing counsel of the APTCL. He has personal difficulties today. Taking into account that the matter pertains to the year 2017. This court accommodates the standing counsel of the APTCL and thereby fixes the matter again on 11th of November 2025. Taking into account that there are various councils who represents the APDC. One of such councils shall duly take up the matter if Mr. K.P. Pathak, the learned counsel, is not in a position to do that. Yes.
At page 68, the
Eight?
order, 68. The order is here, Lordship. If I may read. Whereas a show cause notice dated 4/2023 was issued to Sri Shankar Kalda, asking him to reply as to why his IMFL op shop, presently located at house number 22, Bonful Path, Hathigaon, Guwahati, should not be directed to be relocated to any other suitable place, since on verification, following anomalies were found in the present location. First, there is a clear objection from the residents of the neighborhood in terms of Rule 289 and 295 of the Assam Act 2016. Second, The title over the land is clearly disputed and there's litigation pending. Number 3, the building over the land in question, wherein the IMFL off shop is presently located, was permitted for construction by GMC in the name of Shri Abhijit Roy and not in the name of Srimati Omia Gogoi. Number 4, as per the building permission, the building is to be used for residential purpose and the ground floor was approved for parking, which place is now being used for running the IMFL off shop, which is clearly commercial activity.
Who is Omia Gogoi?
Omia Gogoi, as per the petitioner, she is a landowner. She owns the building and as well as the land. So they have entered into an agreement with Omia Gogoi.
Then is he not the owner of the land?
That is disputed factor, Lordship. This is a dispute between that. One Abhijit Roy is there. He says, I am the owner. Number 5, may kindly see, Lordship. While applying for shifting the location question, Shri Shankar Kulda submitted deed drains of agreement executed by Omia Gogoi, claiming to be the owner of the building, whereas per reports of GMC, the building is in the name of Shri Abhijit Roy. Whereas on 17/2/2023, unsigned reply dated 13/2/2023 were received by this office, which have been duly perused and taken note of all the contention raised therein.
What is the source? You are saying that Omia Gogoi is the owner of the land?
Yes, Your Honor. In the show cause notice which served upon us, we have replied, we are depending on 2 title suits where Omio Gogoi was declared as the landowner and the third suit is going in the civil court. We have also referred to a Jomabandi where the husband of Omia Gogoi, late Torun Chandra Gogoi, name is being shown in land records. And it has also been replied in the report submitted by the circle officer. So, Your Honor,
No, that is okay.
my lord,
Then now the so Omia Gogoi thing is okay. But
Where is
only
it
thing is as regards the objection of 289. You're
289.
concerned with 289.
289. The 75-meter radius comes in play, Lordship.
So who are the 6 who are objecting?
As per our inquiry report, they are the residents. He has submitted NOC of 18 persons, whereas after second inquiry, 24 persons came out, where 18 have given NOCs and 6 of them have left out, say that we have objections regarding that for setting on IMF shop.
6 are within.
The 75-meter radius.
a survey was taken out after.
Then why the 6 are not a party here?
They have not made them a party.
I have not made them a party because these 6 parties, they came up after the complaint filed by the Mahila Samiti. And surprisingly, when the inquiry was conducted, now none of the members of the Mahila Samiti representing the Mahila Samiti was found. It is also mentioned in the report that they have tried and called the Mahila Samiti and none of them has received the phone.
You have passed this order on the basis of whose complaint?
Mahila Samiti, Bonful Pot, Hatigao Mahila Samiti. Hatigao Mahila Samiti Porishad. And the complaint was filed after 24 days of opening of the shop.
The show cause comes at page 57, Your Lordship, Annexure 10.
Where is the complaint?
Page 46. Page 46.
Now, have you made the inquiry with this Mahila committee?
We have called them, they are not appearing.
Huh?
They have not.
First of all,
We have already, we have not inquired with them. But since there's a complaint, only come to show cause notice. The show cause notice contains certain allegations against the petition. Show cause notice dated 4th February 2023 at page 57.
Yes.
first of all, my lord,
Reference to the above, this is an information by order dated to 25/7/2020 under number so and so. You are allowed to shift the IMFL shop from earlier location of new site at house number 22, Bonfur, Hatika. In the rented premises of Shri Umya Gogoi, wife of late Bipin Chandra Gogoi. From the records, it is seen that the land in question is muted in the name of one Shri Abhijit Roy, Director Real XTC Real Estate Private Limited, and in affidavit dated 3/3/2021, Srimati Omia Gogoi claimed to be the owner of the land and executed a land agreement with you while admitting that her name is not muted in the land records. In fact, the NOC submitted by you of Guwahati Municipal Corporation dated 1/12/2021 and 29/1/22, the premises in question was declared as commercial premises of Srimati Omia Gogoi. In the meantime, public complaints were received by the office which compelled to cause an inquiry through Deputy DSC. Kamrup Metropolitan District. In report dated 9/11/2022, Deputy Secretary found that in terms of Rule 295 of the Assam Excise Rule 116, there were already 24 neighbors within the 75 meters on the shop premises, out of which 6 neighbors had objections regarding opening of the shop. Further queries were made from Circle Officer, Dispute Revenue Circle, as well as from the Additional Commissioner GMC regarding status of permission of the building as well as the land. Consequent that, the Commissioner of Guwahati Municipal Corporation in his report dated 6/12/2022 informed that the Guwahati Municipal Corporation approved for RCC G+3 building for residential use and the ground floor was approved for parking. From the NOC of construction issued by GMC, it reveals that NOC was issued in the name of Abhijit Roy Hatigao. From the report dated 27/1/2020 Subject Circle of the Dispute Revenue Circle, it is also revealed the land in question is mutated Ismail in name of Shri Tarun Gogoi, son of Shri Girin Gogoi. From the above, it reveals the location of the site has the following anomalies. The clear objection from the residents of neighborhood in terms of Route 18 to 91 Route 216, that lower land is disputed. The building out of land in question where the IMFL off shop is presently located was permitted for construction by Guwahati Municipal Corporation. Is in the name of Shri Abhijit Roy and not in the name of Ms. Omya Gogoi. As per building permission, building is to be used for residential purpose and the ground floor was approved for parking, which place is now being used by yourself for running the IMFL off shop is clear commercial activity not permitted by the building. While applying for a shifting on location in question, you had submitted deeds of rent agreement dated 29/4/2021, 13/10/1 when executed by Ms. Omya Gogoi claiming to be the owner of the building, whereas per report of Guwahati Municipal Corporation building, it's a name of Abhijit Roy.
My lord, my lord, I totally agree with my learned friend that the title of the land is disputed. The building permission, permission of the said building is also disputed. But in which rule of Assam Excise Act empowers excise to look into land matters? I have an RTI for the reference where excise clearly states that NOC building permission is not required for a IMFL on or off shop to be transferred or shifted. If the building is illegal, who is to decide, excise or GMC?
Up to page 66.
66.
Serial number 1. What did you say? Are you not admitting that 6 persons are still objecting?
6 persons are still objecting, but
Then
18 persons are also.
forget about
supporting.
18%. Can there be one objection also would do as per 289?
But
First, listen. Secondly, why on earth have you mentioned that you have won 2 cases?
2 copies are there.
First of all, do you know what when you win a title suit? How many years of practice do you have? How many years?
5 years.
5 years. Here, you say that there is a fraudulent sale deed executed by on behalf of Torun Chandra Gogoi in favor of Abhijit Roy in the year 2015, which you have challenged it. In the challenge, there is an injunction order passed wherein it has been mentioned that there is not to alienate. You didn't win the case. The suit is yet to be decided. In respect to a case of conviction, the criminal case against your client, against Omia Gogoi, she has been held to be not guilty.
Not guilty.
But does it make that you are the owner of the land?
No.
The land is admittedly, as on date, belongs to Abhijit Roy. It is apparent. This is your statement. I'm not saying from anything else, from your submission, from your show cause or reply. Secondly, out of 24, you admit there are 24 persons. Out of six are objecting. Then, how many persons objection is required?
It is not specified in this act.
Then, so any person objecting would come under 289.
But it is not.
You need to be more careful when you are making this submission before the court. As on date, the name of the land belongs to Abhijit Roy. You say, although in the ground floor it is parking, but it has been constructed outside. Can you have a licensed premises in an illegal construction?
No.
Then, whether in the drawing there is a particular house given or the particular room given out there in the drawing.
That I have not seen.
Then-
I have not seen the building permission drawing.
You have specifically mentioned out here in your case to that effect. You have been asked to shift to some other locality. Why you are not shifting? It is a privilege. You have to understand. They are asking you to give you an opportunity to get another room. Get a room.
And the order dated 23/3/2023, there was a given the direction of petitioner to produce a fresh NOC, which till date they have not produced, and even giving them an opportunity to find a suitable location and option. They have not done it yet.
Find a suitable location. Nothing more than that. As per 289, that particular paragraph,
Yes.
if there is an objection, then you have to file a suitable location. There, you admit in your reply that there are objection of 6. And you have not made those people a party also. Neither you have asked these people that look here, kindly give me the names, I'll make them parties. They are not alleging out here that Hathigaon Mohila committee is objecting in the show cause reply, show cause notice. The action is being taken on the basis of the show cause notice. They categorically say that after everything has been done, we made an inquiry and found out that there are 24 residents who are living within 75 meters. Out of that, we inquired and found out that 18 says that we have no objections, 6 has objections. You also say that yes, 6 has objection. So what? Is it the mandate of law under 289 that if there is an objection, can you be permitted to run? Because you have to understand, this is not a right, it's a privilege. Then the act only grants certain privileges to you. That is why it's these things. Can it be just for if you are selling vegetables or if you are selling any, just for example, any other goods out there? Can you categorically say can they have the other residents objecting? No. In liquor, it can be because of the fact that the directive principles of the state policy also say. And because of that, it has not attained the status of a right. It's a privilege. Your right is only right is there of being not given due opportunity, which amounts to fair treatment. And that would be a violation of Article 14, nothing more than that. But if you don't comply with the provisions of the law, cannot be. You cannot have a licensed premises. Nowadays, you see these licensed premises in a big malls and all like this, it has been done. But you have to understand, these licensed premises always were under fetters. No person could go inside. There is a manner in which it used to be. You have to take special permissions. Then you think that it is any other shop.
Your Honor.
Then you have enclosed a Jamabandi, but without enclosing that there is a sale deed. Legality or illegality is a different aspect of the matter.
It is not with us, Your Honor.
No, understood. But you say that there is a
It
sale
is
deed.
not with us.
You are saying that. At least come here.
But sale deed is, a copy of the sale deed is not with us.
No, it is okay. But kindly come to paragraph page 64, the third paragraph. Are you not saying
Development agreement.
legality or illegality cannot be decided by me? It has to be decided by the trial court, neither by you. So as on date, it is a property belonging to Abhijit Roy. So what should I do, Mr. Gogoi? Dismiss?
Dismiss. I think
And-
allow me to shift, Your Lordship. Allow me to shift from the current location to new location, give us a proposal for shifting.
Give him some reasonable opportunity.
And anyway, we have already proposed him, he has replied to it. Now we'll give a reasonable time to allow him to shift. Because the land is completely in dispute, Your Lordship. And he has entered into agreement with one Omiya Gogoi, who's stating that I am the land, I am the owner. Abhijit Roy comes says I am the owner. So that has not been decided yet, who's the actual owner. He had entered into agreement with one Omiya Gogoi. Whereas she stated that her name.
No, all the other things are different, but 289.
289 numbers comes, Your Lordship. That even it's one person also. There are
One person is enough.
enough.
That is the sad part when you are having this business. You have to satisfy everybody. Hello, we dismiss it on first. List this matter for further hearing on 1/11/2025. At item number 4.
Obliged, Lordship.
Yes, those matters, whose matters are there? I can't provide. Huh? And item number that, on which date an attempt shall be made to dispose of the resolution. Showing it as it's the matter as Arthur on so and so. An attempt shall be made to dispose of the resolution.
Item
Yes.
5.
What is this?
My lord, very short issue, my lord. Issue is, my lord, what happens in this case, my lord? The petitioner in this case was a settlement holder of a Hillstone query from 2011 to 2016, my lord. Under the provisions of Assam Minor Mineral Concession Rules 1994, he successfully operated the Hillstone query. But in between, my lord, that 1992-94 rules repealed. and 2013 rules came into force. Then, my lord, petitioner has paid all the kist money, etc. And subsequently, my lord, one letter he received after 2 years, 1 month, that is on 2018-73, my lord, page 73, my lord.
You've been asked 6x 5,000.
Yes, my lord.
Then why are you?
My
not
lord, I
paying?
have said that the contract agreement was under 1994 rules. There is no provision for payment of MMDR, my lord. There is no provision, my lord.
And
1994
this
rules,
6
there is no
lakh
provision,
5,000
only
is for MMDR.
MMDR.
Contract agreement was for the year.
1994 rules, under 1994, earlier rules, my lord. That was repealed already.
When was the contract agreement entered into?
My lord, that is 2011.
2016.
2016 and my lord. My lord, lordship may kindly page 40, my lord. That is the agreement for lease. That is on
Then it should
22nd
involve
July
hearing
2011.
Whether Rule 59 of the Assam Minor Minerals Concession Rules 2013 could be applicable in respect to your contract.
That is the only issue, my lord. That is the only issue.
Rule 79, your lordship, the Assam.
Rule
Mine
Rule 59 or 79?
79, 79,
Ripple and saving clauses there, your lordship.
79, my lord.
Rule 79, ripple and saving clauses there.
No, it's okay. Rule 79 is the repeal and saving, but Rule 59 is the MMDR.
MMDR.
MMDR, my lord.
Is 58. Sorry. Yeah,
59.
58.
58, my lord. Yes, my lord. Chapter 11.
Samana, you got to stay.
Yes, yes, my lord. Some other day, my lord. And today, your lordship can sufficient, my lord. Sufficient matter, my lord. Already from morning here, I am sitting here, my lord. So, lordship, some other day, my lord.
No, only the question is repealing and saving.
Yes, yes.
Because you got the contract in terms with the earlier rule. So therefore, by way of this new act,
Yes.
unless Rule 79 permits, you can.
Then, my lord, contract agreement was also not modified as per the 2013 rule.
79 clearly has a
2013
clear statement,
rule.
your lordship, provided that wherever the terms and conditions of any mild concession granted before the commencement of this rule are inconsistent with or repugnant to this rule, the same shall be deemed to have been modified in accordance with this rule from date of notification thereof.
As per the said, my lord, contract agreement ought to have been modified, my lord.
No, but if it is statutorily modified, then you don't need to, unless you challenge.
Yes,
If
that is the
challenge
only
Rule
issue.
79. You have to come and
That is the
challenge.
only issue. Lordship will take some other day.
He is also finding it difficult to find a book. The winters have arrived. So the ports finishes at 4:30. And Mr. Sahu, your matter should not have come up so early. It should have come as in 2020-35. Not before that. I fixed those matters for issuing rules and for hearing. I should take it up with the what do you call, the registry as to why these matters have been listed. Isn't it? Is there any urgency? No, it isn't. He also doesn't have any urgency. He only sought, there are matters which are pending of the labor court which requires urgent disposal and all. Leftover. Leftover, should I make it leftover? That come up in the part 2 is not there. He matter to দিব. When do you want the dismissal?
Lordship convenience, my lord.
No matter. Okay. Let us have it on 18th of November. Is the matter on 18th of November? On which date an attempt shall be made with whole of the petition. লিখিত matter দিব। The petitioners have filed an affidavit in reply. Mr. K. Gogoi, the learned counsel submits that he would like to take instructions in that regard. This is the matter for hearing in the usual course.